After vacation. Yes.
The similar matter has been disposed by this one.
After vacation. No, after vacation. No, Mr. Mishra, after vacation I have said.
Another case, my lord, interim.
I have said no, after vacation means it will come after.
Sorry, my lord, I want to interfere, my lord. On the interim application was allowed in respect of other other bail application.
So,
Otherwise, that will be in process.
so what is the urgency? Tell me, please tell me.
On the prayer of the OPID council, my lord, matter was urgent to 6 months. But it has not been listed, my lord. In another case, my lord, the interim order, your lordship granted interim application file for month, my lord. And that will be in process, my lord.
How will it be infructuous?
If, my lord, in this case, if they will not release, my lord. Another bail application interim order was passed, my lord, by your lordship.
Give the memo, I'll see. I'll call for the file and see, and if I'm convinced, then only I'll allow.
Yes, sir.
No urgency.
The authority as well as the villagers not allowed the petitioner to discharge her duty on the allegation that the petitioner has an extramarital relationship.
No, we'll see. Let it come after vacation, we'll see. Yes. No. After vacation. Yes. Item 1.
Supplementary list, item number 1, fresh admission.
Yes.
May I please? And in this case, when the the counsel of the present petitioner cross-examines one witness, where the prosecution case is FIR against unknown. There, in course of investigation, some of the witness stated that one chappal was found at the spot. That is the one of the accused, and he the accused was related to the deceased. I also read my 161 on page 42. Relevant part
matter Mr. Raut, what is this? What is this matter? Who are you? Which case you want to be transferred from which place, which court to another, which court, and what is the reason for your seeking a transfer?
This is I am coming total to the reason of the transfer.
No. Who are you? First tell me.
I am the one of the accused facing trial before the London.
CORAM there and Lakshmi Priya there. There are two petitioners.
Two petitioners.
Both of them are accused. What is the case?
Case under section 302 and 120B, 201 and 34A.
So it is pending before?
London additional session judge Salipur.
And you want it to be transferred to the sessions court?
To any other court.
Why?
Because of their non-cooperation in open court, where there is relevant some question. The counsel put the question and he denied, and he also written in the cross-exam in his deposition. And it's also reflected in running post 49 cross-exam para 16. And thereafter, when the counsel was taking times or taking a accommodation regarding the...
So you challenge it.
Ismail.
You challenge it, filing a 482. You challenge it or file a revision the matter number 1, file a 482.
Well, before that, since then, in open court, you will not get any relief from my court, and you will be punished in open court in that trial. कारण जितेबेले गोटे साक्षी कहिजी जे घर निकट रे छाडी जाइथिबा लक्ष्मी रो
where have you said that in your petition? Let us see. Where have you said all these things in your petition?
Earning page 43 161 of that.
No sir, where have you said all these things in your transfer application? You are making allegations against the judicial officer, mind you, and of the rank of district judge.
It also
I don't know. It is up to you. It is up to you. You are making allegations.
But what I am also on that court, I also the conducting counsel.
Yes. So tell me, where have you mentioned it in your transfer application? Let me see. What is your allegation?
Para 8 minor kinds.
Para 6 is there. When the defense advocate cross-examined, the learned court did not allow to the defense counsel to put the question regarding shoes. Then para 8.
Para 8.
No, para 7 also during the learned court, there is no sympathy. No. This is not a ground for transfer, Mr. Raut. This is not at all a ground for transfer. He, according to the court, the question that you put, there are 3 parts. First part is that the question that you put, according to the court below, were not relevant. He has recorded it. Challenge it.
Challenge
it in the High Court. The High Court will decide whether the question is relevant.
But other things was the council prayed that no, that I will not absent on 10. No sympathy. But I am telling on that day you will also present. Otherwise, 10, no sympathy, I will give you challenge further. That part accused was not produced. They are not disputing. I file a medical report. On that record to dispose of call for a medical report from the jail with the one.
It is open to it is open to you to challenge it, but this cannot be a ground for transfer, Mr. Raut. So if you want to challenge, you challenge it. Challenge it. I pass the order then. I'll not interfere.
Yes.
The
To the liberty to be granted to challenge in this regard only.
you don't need any liberty.
Yes, yes.
You don't need any liberty.
Yes.
The petitioners are facing trial as accused persons in GR case, ST case number 112 of 2022, pending in the Court of Learned Additional Session Judge Salipur. Stop. They seek transfer of the case from said court to the Court of Learned Sessions Judge Cuttack. The grounds cited are as follows. 1. On 12/3/2024, the prosecution examined PW4, and when the defense counsel wanted to cross-examine, the court below did not, the trial court did not allow him to put a particular question regarding shoes. Stop. B. The court below is not, the trial court is not cooperating with the advocate and the accused persons, and there is no sympathy and mentioned in writing in the cross-examination regarding non-relevance of the questions put. Third, the trial court, despite request of the accused persons, did not give any, did not fix the case to a suitable date, and allegedly misbehaved with the defense counsel as well as the accused persons. So, para. According to the considered view of this court, these cannot be reasons for transferring a case from one court to another. Stop. If, according to the defense counsel, according to the defense, certain relevant questions were not allowed to be put, it is always open to it to challenge the same, challenge such order of the trial court before the higher forum. As regards the non-fixing of a suitable date by the trial court, this court is of the view that the looking at the stage of trial, a date suitable to all parties, including the court, can always be fixed, but only because a particular date was not fixed by the court cannot be a reason to doubt the fairness of the presiding judge. So, next, as regards the so-called misbehavior allegedly exhibited by the presiding judge, this court finds the same entirely unspecific, non-specific, and vague, so as to take cognizance of. In such view of the matter, this court is not inclined to entertain the application, entertain the prayer for transfer of the case. Stop. The transfer application is therefore dismissed. Yes. But I've made that observation, you can challenge it. Yes.
Item number 2.
And even otherwise this order, if you place it before the court, she ठीक line को पड़े best one.
I also filed on in this regard a petition on that date for transfer of the grip to any other court. That will be also pending. And one recall petition was filed. That was also pending. This is the they will the harass and all the
So you make out a case accordingly. You make out a case accordingly. As you say, you have filed a petition for transfer.
pending also.
Let it be decided. Let it be decided. Yes.
Item number 2.
The claim of the petition for appointment of Anganwadi worker was rejected by the
Testing the correctness
at
of-
Annex 12 on the region for not see the
Where is the implement order?
my lord,
Where is the implement order?
implement at Annex 12 mail.
Annex 12. This is a 2017 appeal.
Mail.
So I think the old
Yesterday also, my lord, notices were issued.
notice will issue notice. Okay. You what is the fact? What are the facts? You were selected as Anganwadi worker.
Selected, not selected. On the ground of the resident certificate not produced, that is rejected. The resident certificate was produced at the time of application under Annex 5 mail.
So that was ignored.
Ignore mail.
Okay. Well, I take notice. Learned State Council. I think there's a party sector supervisor of ICDS project.
Sector supervisor.
Is it necessary? Is it a necessary party?
My lord, conducted is inquiry, my lord.
All right. Then I think you can appear.
Yes,
All right. Learned State Council accepts notice on behalf of all the opposite parties except opposite party number 7. 1, 2, 3, 4, 5, 6, 7. 7 extra copies of the writ application be served upon him within 3 working days. Issue notice to opposite party number 7 by a registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days. List this matter.
26 June, sir.
No, per
10th July.
10 July.
Mail.
Item number 3.
May I please, Your Lordship?
Yes.
All these matters are covered by the judgment of Dhananjay Charan De, which has been confirmed in the Honorable Apex Court, my lord.
Dhananjay Charan De. So individual application, individual representations.
To be examined in that light.
You do one thing.
Yes, my lord.
The representations have you submitted?
Yes, we will submit fresh representation if
Then we will
not-
say request representation to be submitted individually.
Yes.
Why doesn't the government come out with a definite policy?
Yes.
There are hundreds of representations the government will have to now decide.
Now, since your lordships have thrown the burden on them, they will be compelled to come out with a policy.
So they should.
This
Because
will be a
The
lesson
law has
to
been
them.
laid down by the Apex Court. This is relating to that career advancement.
That have come
Yes,
by
my
now.
Whether the previous that Ganashikhyaka period
Yes, my
will
lord.
be taken into account or not. This is that period.
Yes, my lord. The Gona Shikyaka are appointed against the existing vacancy of the Sikha Sahayak.
Yes, sir.
Yes,
Yes.
my lord. But the Gona Shikyaka are regularized in 9 years, whereas Sikha Sahayaks were regularized in 6 years, my lord.
Yes.
So our claim is as we are appointed against the existing vacancy of the Sikha Sahayak, so our regulation also should be counted from 6 years, my lord.
Yes, that has been decided by this court and confirmed by the Supreme Court. Now, so they should come out with a policy.
Yes.
Now they cannot because the election is going on, so they cannot. It requires a government. It's a policy decision. Anyway, so Dhananjay, all these matters are same.
Yes, my lord.
All right. Yes.
Item
Obliged,
number 4.
No, on where Mr. Jekyll pass over one pass.
Which one? Item 4.
Item.
All right. Pass over.
Item 5.
So Maharana is not there. As to when the petition filed by Sarathi Charan Saw, that is OJC number was disposed, we will pass it over. Let him come.
Detail.
Detail civil matter.
I'll then wait.
That's yes.
Yes.
If you can inform Mr. Maharana, the Central Government Council. Yeah.
Yes.
Amar kya chun? Amar ka phone.
Hey.
Please inform.
I'll try also.
Yes, if you have the number. Yes.
Item number 6.
May I please, your lordship? No, this is it's a
Yes.
matter related to disengagement of that Ghana Sikshaka, my lord. That's a yesterday the matter.
Yes, yes.
Yesterday the matter was on the list and partly had and listed today.
What had?
My lord. My
My lord, that is the case, my lord, wherein this petitioner was
Oh, jail
jail
custody
custody.
beyond 48 hours
my
beyond 48 hours.
without giving him any opportunity.
my lord.
So I examined that matter.
I may
To that extent, my lord, they have admitted that he was in fact dismissed or disengaged from service, taking into consideration the conditions stipulated in the advertisement.
Let us go to the advertisement.
No opportunity was given. Clause number 4, my lord.
And subsequently, you have been acquitted.
my lord.
Yes. That is what we have
The
stated, my lord,
persons
after
enriched by
acquittal.
the Annexure 1.
After acquittal, he had not challenged, in fact, my lord, in Annexure 2, the order of disengagement. In this case, even.
I couldn't follow.
My lord, there is an order of disengagement.
Yes.
This order of disengagement has not been dismissed.
Annexure 2.
Annexure 2.
My lord.
He never
But-
challenged it.
Nah.
Okay.
Then thereafter, my lord, when he faced a trial and thereafter he got acquitted,
Okay. Okay.
then made a repentation before the authority.
Then that will be
Immediately-
considered. Then that can only be
My lord,
considered.
that
My
is
lord,
what-
the trial, the allegation is on August. He is acquitted on April. Within that time period, after immediately thereafter on 19/5, he made the representation.
repentation. And that repentation has been rejected.
Then he immediately
And thereafter
filed
he
this
filed
writ application.
So, my lord, the point that, my lord, that when this judgment of acquittal was on account taking into consideration the fact that there was a compromise between them, as it has been placed before lordship on the last occasion. So that has been taken into consideration by the authorities at the time of rejecting his repentation.
No, even assuming, let us for a moment, let us keep that acquittal order aside. The only problem is that she had not challenged that order per se.
Understood too, understood too.
Had you challenged it, then I would have set it aside on the ground that the principles of natural justice have not been followed. I would have set it aside because you have not been given an opportunity. Now you waited till the acquittal order came. So only now the only corollary is that the court will direct the collector to consider the effect of acquittal.
My lord, that is within the 8 months time. The immediately, my lord,
ମୁଁ ବୁଝିନଥିଲି ଏଠି ଆସିଲେ ଆପଣଙ୍କ ପାରା
but my lord, the disengagement is also that is violate the principle of natural justice. In the advertisement in para.
Ms. Rai, come to your paragraph prayer.
Okay.
Please read the prayer.
My
What?
In the view of the aforementioned facts and circumstances, it is therefore prayed that your lordship may graciously be pleased to admit this writ application, issue notice to opposite parties to show cause as to why the order under Annexure 5 shall not be quashed and why the petition shall not be re-engaged as Gana Sikhyaka as before, after acquittal from the criminal charges of the opposite parties failed to file show cause or files in the insufficient cause, then rule nisi will be made absolute against them as and your
Against no, against.
against
Against no.
against them.
Against.
My and your lordship further be pleased to pass any
Sorla. So Annexure 2 आपने challenge करना? You have challenged Annexure 5, which is rejection of your representation. Isn't it?
Right.
So what to do? Lordship may interfere with this Annexure 5 with proper observation and direction.
after so that is not.
Here, no mandamus can be issued because Annexure 2 has not been challenged.
Proper-
I can only set aside Annexure 5,
with
saying that you have not, what he says, you see Annexure 5.
Page note
He had
23
submitted a grievance.
Page note 23 and 24.
He had submitted a grievance.
Yes, ma'am.
Where is the grievance letter?
Grievance letter is at page number 21.
अच्छा, इथे कौन लिखले?
ସେଟା ସେ ଲେଖିଲେ ଯେ ସେ ଡିସେନଗେଜ ହେଇଛନ୍ତି 16/8/2013 ରୁ
मान्यवर जिला दौरा कोर्ट निकटरे मु न्यायाधीश କରିବା ପରେ मान्यवर कोर्ट मते उक्त मोकदमा कोर्ट so after acquittal she has submitted a representation. That is the mistake. Otherwise only on that ground that you are not given an opportunity the Annexure 2 would have gone. So now the only thing that the court can direct is to
interfere with this Annexure 5 and to direct the authorities to.
okay, we'll see how what best can be done. God helps those who help themselves. And if you don't help yourself, how can the court help you? You have to give a handle to the court. You should have challenged Annexure 2.
Right.
And it's too late in the day to challenge because the writ petition was filed 10 years before.
Right.
You have got a clean order. Anyway, we'll see. The petitioner has approached this court. Hey, Mr. Marana is there. Yeah. The petitioner has approached this court with the following prayer. Para. The facts of the case, briefly stated are that the petitioner was engaged as Gonosecure as per engagement order dated 14/7/2008 and was allotted to to Kochila Bellary Propius
Project Primary
Primary School in the district of Kendrapada. While working as such, he was involved in a criminal case being criminal case being Mahakal PS case number 186 dated 16/8/2013 corresponding to GR case number 1018 of 2013 of the Court of Learned Sessions Judge comes Special Judge Kendrapada under sections 341, 354 capital A IPC and section 10 of the POCSO Act. By order dated, he was taken to custody and subsequently released on bail. By order dated 18/9/2013, the collector cum chairman SSA directed his disengagement on the ground of his detention in jail custody beyond 48 hours. Subsequently, as per judgment passed on 30/4/2014 in the aforementioned criminal case, learned Sessions Judge. Mr. Naik, please. Mr. Naik, please slowly. I'm getting distracted. Learned Sessions Judge held that the prosecution had failed to bring home the charge against the petitioner and therefore acquitted him therefrom. Pursuant to, after passing of the judgment, the petitioner submitted representation dated 19/5/2014 and 18/9 representation
18/8/2014.
19/5/2014 and 18/8/2014, bringing the fact of his acquittal in the criminal case to the notice of the authorities. Stop. The representation was addressed to the block education officer. Stop. By order dated 21/8/2014, the collector rejected the
Paragraph number 6.
Rejected the representation of the petitioner. Inter alia, holding as follows. Para 6 of quote karo. है ना? Miss Agnishika Rai, learned heard Miss Agnishika Rai, learned counsel for the petitioner. Counter affidavit has been filed by the state opposite parties justifying the action taken against the petitioner. It has been stated that the petitioner was disengaged because of his detention in jail custody beyond 48 hours. Because of his detention in jail custody. Thereafter, he faced trial and was acquitted. However, clause 4 of the engagement order of the petitioner as Gonosecure clearly mentions that a Ganashikya can be removed from the engagement within 30 days, prior notice. No, without prior notice. If he or she violates the conditions stipulated in the engagement contract. It is further stated that mere acquittal in the criminal case does not grant any right on the petitioner to be reinstated as Ganashikya. Moreover, he has not been honorably exonerated, and only because of compromise by the victim's family, he was acquitted. Heard Ms. Agnisikha Rai, learned counsel for the counterfile question, Dita counterfile the same counter. Oh, same counter probably.
213.
Heard Ms. Agnisikha Rai, learned counsel for the petitioner, and Sri S.N. Patnaik, learned additional government for the state. Additional government advocate, I think for the state. Ms. Rai submits that once the petitioner is acquitted from the criminal charge, it cannot be said that the allegations leveled against him, for which he was removed from service, had any basis. Moreover, the competent court, being the Court of Sessions, having passed a judgment of acquittal, it is no longer open. It is not open to the collector to sit and appeal over it and make his own interpretation. Stop. Sri S.N. Patnaik, learned AGA, would submit that law is well settled that mere acquittal in a criminal case on the same set of charges does not necessarily result in does not lead to automatic exoneration from the charges in the departmental proceeding. In the instant case, the petitioner, being a contractual employee, was disengaged because of his involvement in a criminal case, and that too involving offences of moral turpitude. Stop. Reading of the judgment of acquittal would make it clear that that because of non-cooperation by the family by the victim and her family, the charges could not be established. Stop. This is not akin to an honorary and honorable acquittal. That is it, Mr. Patnaik?
Yes.
That is all?
Yes.
After hearing learned, the facts of the case are not disputed. Stop. This court finds that there is no condition in the engagement order granting power on the authority to remove a Ganashikya only because of his involvement in a criminal case. The petitioner was disengaged on the ground of his detention in jail custody beyond 48 hours. Evidently, the collector was influenced by the corresponding provision in the Odisha Service Code available for government servants. That is, সেটা ক্ষেত্রে rule ক্ষেত্রে 48 hours rule 12.
না, সেটা হচ্ছে OCSCCR,
OCSC, I'm sorry. Smooth service code.
OCSCR matter.
Rule 12 না?
Rule 12.
Rule 12 of the
Rule
OCS.
12 Rule 12(2).
12 কয় দিন হবে? Rule 12 of the OCS CCA rules, which needless to mention does not apply to the Ganasik case. So be that as it may, this court also finds that no opportunity of hearing whatsoever was granted to the petitioner before taking the extreme step of disengagement of his services. So be that as it may, the learned sessions judge in his judgment held that the prosecution miserably failed to bring home the charge against the petitioner, for which he acquitted him therefrom. Stop. In paragraph 7 of the judgment, learned sessions judge has mentioned that within inverted comma, the informant has deposed during cross-examination that the matter has been compromised out of the court and he did not want to proceed further in the case within inverted comma clauses. Stop. Obviously, comma, this is not the finding of the learned sessions judge, but reference to the statement made by the informant during cross-examination. Stop. The collector appears to have been the collector while referring to the above statement mentioned in the judgment went on to hold as follows. Para 5 to court. Stop. This is nothing but sitting in appeal over the judgment passed by the competent criminal court. Stop. It is relevant to, it would be relevant to state here that the state never challenged the judgment of acquittal before the higher forum, and therefore it has become final. Stop. Such being the facts, it is not open to any authority, much less the collector, to interpret the judgment in a manner that is contrary to that contradicts the ultimate finding rendered in the said judgment, that is of acquittal. Stop. The further finding under paragraph 6, already quoted here and before, is also runs entirely contrary to the findings of the learned sessions judge, which, comma, in the circumstances is not permissible in the eye of law. Stop. For the foregoing reasons, therefore, this court is constrained to observe that the matter was dealt with in from an entirely erroneous perspective, And therefore, the impugned order under Annexure 5 cannot be sustained in the eye of law. So what order can be passed? We'll set it aside. We'll direct him to, since he was reinstate karibe apun.
Since the disengagement was on account of involvement in the criminal case. So the obvious result is that.
କିଛି reinstate କରିବେ reinstate କରିବେ ନା କୋଣ ଏଇଭଳିଆ ତମେ sessions court the district judge will pass a he is the competent criminal court, he will pass an order, you will interpret it. ବେଶୀ ବୁଦ୍ଧି ଆଉ କଣ ଲେଖିଲେ last time perspective. Stop. Further. No, further. Moreover, comma, as already stated, no opportunity of hearing whatsoever was granted to the petitioner before issuing the order of disengagement of his services. Stop. Since he has not challenged, I will be taking all these facts into consideration, therefore, the rate application is allowed. The impugned order under Annexure 5 is hereby quashed. The opposite party authorities, opposite party number 2, is directed to pass necessary orders reinstating the petitioner in service as early as possible, preferably within 2 months from the date of production of certified copy of this order. Stop. It is, however, made clear that the petitioner shall be entitled to notional benefits only from the date of his disengagement without any financial benefit. Yeah. Yes?
There is one IA.
What I?
My lord, IA is regarding that the modalities given to the Ghana Sikyaka, that there is some eligibility conditions, and there is a condition that if a person is completes the a period of 8 years and there is some qualification, the person is already qualified for that purpose.
Notional. That is why I have said notional.
Notional.
IA not pressed. IA not pressed.
Right. There is जो 5 वर्ष से चाकरी करছে সেই 3 ବର୍ଷଟା
ସାପର ଗୋଡ଼ କୋଣ ଜାଣିଛନ୍ତି?
sorry
ସାପର ଗୋଡ଼ କୋଣ ଜାଣିଛନ୍ତି? ଜାଣନ୍ତି. When I have time, I'll tell you. You will understand. ଯେତିକି ସରିଲା ଆଉ ବିଲକୁଲ କୁହନ୍ତୁନି. You have never challenged that order of disengagement.
I beg.
Yes. Yes. हाँ पासवर्ड किती?
Right number 5.
I beg your pardon.
That's all. Are you ready with that?
I only pray, next Wednesday actually I pray.
Next Wednesday. All right. Yes, Mr. Das.
I also request my lord.
All right. Sri Maharana and CGC requests for some time to comply with the previous order. Let's this matter next week. The previous order be complied with positively. Yes. I would tell you. Now to next Wednesday.
Beg pardon.
It will come next Wednesday.
My lord.
Item 7.
Item number 7.
I am for the respondent, my lord.
Item 7, yes.
May I please, your lordship?
Sir, second appeal or matters, sir, you should come physically. Anyway, place it. Place it, Mr. Mishra. I am not very comfortable in final disposal matters when you are arguing through virtual mode. Anyway.
Tomorrow, my lord.
No, anyway, Sardava, go on.
My suit for partition was filed by the plaintiff respondent.
Yes.
But this
Copy of the memorandum of appeal may kind be provided, my lord.
Why? Only if I admit. Only if I admit the case. If I don't admit the case, why you don't come into the picture at all?
Well, I have held the cabinet.
No. Let me see. Has it been admitted? Has the case been admitted?
Well.
Yes, Mr. Mishra?
Madam.
The suit was filed.
Has it been admitted?
No, my lord, this is coming for.
This is the reason why I am saying that you should appear physically. Second appeal virtually karibe.
Na kali karibe.
No, sir.
I think your lordship is not valid.
No. Don't think much. Just argue. Leave the thinking to me.
My lord, the suit for partition was filed.
Yes.
Claiming that, my lord, A to E schedule property are the property of the common ancestor, and in fact, they claim that it's a self-acquired property of the common ancestor, and she claimed that this schedule property has been sold to her. The lordship gives a categorical finding. The lordship will see that there's
a genealogy here.
My.
Is it necessary? Is it relevant to refer to that?
Genealogy is not in dispute. What is in dispute is, now we have said there was a prior partition.
Oh, prior partition, yes.
The learned trial court, on consideration of the same, my lord, the lordship will kindly turn to, my lord, the finding, that is finding on issue number 3 and 4 is very vital. May I
issue number 3. Issue number 3 is whether there was previous partition in respect of suit schedule property. All right.
That's obliged. Then 4 is whether the plaintiff is entitled for partition in respect of A, B, E, F, because she says D he has purchased, and C also she claims for a declaration. So therefore, she has only claimed for partition in respect of these 4 schedule of properties. Now the learned trial court decided issue number 3 and 4 together, your lordship.
Yes.
Then comes to a conclusion at page 18, your lordship.
Page 18, all right.
The other schedules have been dealt with, and ultimately at page 18, learned trial court says.
Yes.
May I just draw your lordship's
yes, please.
The last 4 lines of page 18. As revealed from the RORs, there are 5 plots of so-and-so, but the plaintiff has asked for partition only in respect of 4 plots, excluding plot number so-and-so. The reason best known to the plaintiff. So in view of the confusing, ambiguous pleadings as well as the inconsistent, confusing evidence of the plaintiff is not entitled for partition. The learned trial court rejects it. Then so far as the declaration part is concerned, issue number 5. Your lordship will kindly turn to page 23, your lordship.
Yes.
That also again the learned trial court says that it is, I'm not inclined to allow any declaration in favor of the plaintiff so far as C schedule property are concerned on the basis of fanciful, shrouded with absurdities and non-specific pleas, and hence the above issues goes against the plaintiff. And here, I beg to point out to your lordship one thing. So far the claim of right is concerned, the pleading is at page 5 of the judgment, wherein she says, though Kailash Pantho wanted to sell another plot, erroneously another plot was mentioned in the sale deed, which was sold earlier. That is the plea on the basis of which he claims the right, and the right has been negated by the learned trial court. Now the learned appellate court, your lordship will kindly see the judgment next to the learned trial court judgment that has been enclosed. Your lordship, the learned trial court takes note of the pleadings and the issues, then proceeds to decide the case at page 8, paragraph 12.
Yes.
Then, my lord, here the parties have dealt with and transfer has been effected also by the party, including the plaintiff. That has been taken note of by the trial court. Now, the learned appellate court dealing with this from paragraph 12 comes to a conclusion. Then he quotes the Faisla Patra at page 10 in English, and then comes to a conclusion at page 13, your lordship may kindly turn to. Page 13, one line I beg to show to your lordship. Thereafter, I will show to your lordship how my decision has been.
Yes.
Page 13, towards the lower middle portion, it is apposite to discuss that the plaintiff with all particulars in the deed has mutated her purchased land in her name in the year 2009. This is claiming from the common ancestor Bantha, my lord. The genealogy your lordship has been pleased to see. He has purchased land, my lord, and claimed right over the same. Then the land trial court, the land appellate court proceeds, and ultimately, my lord, though no individual finding has been given, he gives a finding. Page 14, your lordship may kindly turn to.
No, but what is wrong in it?
Now the wrong is this. My lord, your lordship will see
Yep.
that this is a reversing view. One view is one way and the other is this way. Therefore, the substantial question of law at page 12, your lordship. May I humbly pray, your lordship, may kindly pray.
These are all factual.
But this is a perverse finding. I have said, your lordship will kindly.
Where have you said that? Perverse finding kotha ekta code likhle.
My lord, because his case is, your lordship, when the plaintiff has admitted that the case land is self-acquired property of Satyavanta, that is the common ancestor. And further, when Satyavanta during his lifetime has distributed the property amongst his children, which will be evident from document by the exhibit E by 1.
So the finding that the land is ancestral property and that finding is perverse according to you.
That's what I beg to submit. And my lord, my formulation of the substantial question of law can always be modulated by you.
No, that's all. That is all. That is beyond doubt. But the thing is, so your entire case rests on this finding that the property is ancestral property, which according to you is a perverse finding, which is against the weight of the evidence on record. All right. All right. Heard Sri Samir Kumar Mishra, Learned Senior Counsel with?
My lord, Sushrita Sahu and my friend Mr. Jagjivan Pradhan is present in court before your lordship.
Yes, what is your good name?
Jagajivan Pradhan.
Jagajivan Pradhan.
Okay.
With Sri Jagajivan Pradhan, Learned Counsel for the appellants. Sole appellant, I think.
Sole appellant, different number 20 appellant.
After perusing the impugned judgments, after considering the submissions and perusing the judgments and considering the grounds raised, the second appeal is admitted on the following substantial question of law. Look, whether the finding of the court below that the suit land is ancestral property is perverse, being against the weight of evidence on record. Yes, you have appeared.
My lord.
I'll wait. So notice need not be issued. You have appeared for all the respondents.
Only respondent number 1, my lord.
Only respondent number 1.
The plaintiff.
So you will have to take notice on others.
My lord. I'll take notice, your lordship.
Respondent could लिख ले यहाँ versus could लिख ले यहाँ पाऊँ
My lord, page 1, plaintiff and appellant in the trial court and lower appellate court respectively.
That is the Jyotsna Priyambada.
My lord. I'll serve a copy on my friend. I request my friend to provide his number to me so that I can serve a copy.
Sir, court लिख ले respondent माने कहाँ थी? ये तो plaintiff चली जिंदी ना?
On next page, your lordship.
Next page रे court ही versus का court लिखा ला नाम पाइलू 2, 3, 4, 5 तो चली ला.
आज्ञा.
लिख ले.
हाँ तंग लिखी respondent number 2 to 9 were defendants so and so and
बुझ पा लेंटी के.
My lord, court.
अच्छा. So he is appearing only for respondent number 1, that is Jyotsna Priyambada.
आज्ञा.
You will take notice on all of the other respondents.
I have to take notice by suit for partition.
Yes. You are Mr. Ratha, isn't it? Full name, please.
Siddheswar Ratha, my lord.
Sri Siddheswar Ratha has entered appearance for respondent number 1. Hence, no notice need be issued to the said respondent. A copy of the appeal memo be served upon Sri Ratha within 3 days. Issue notice to respondent numbers 2 to 9 by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Next para. Call for the LCR. Yes, what IA?
I am praying for final decree proceeding has been initiated. I pray sealing and signing may be statement because that is usually your lordship considers. My lord.
All right. Yes, Mr. Ratha. Yes, appropriate caveat.
True it is, my lord, but that is the usual protection. Your lordship has been pleased to admit the appeal.
We'll fix a date after the vacation. Till such time, the decree will not be sealed or signed. What do you say?
My lord, final decree proceeding is going on, my lord. Entry model will be passed by law.
Proceeding will go on, but the decree will not be sealed or signed till the next date. And I'll fix a date, we'll complete it.
Fine.
Had it not been for that perverse finding, I would not have even admitted the appeal. But it's a reversing judgment on that finding, which he claims to be perverse, and prima facie it appears to be perverse also. Let us see. Yes, IA 1327 of 2023. Final decree proceeding by CS number 250 of 2011 bracket FD pending in the Court of Learned Senior Civil Judge Noagar shall continue, but the decree shall not be sealed or signed till the next date. All right?
Grateful mind.
Yes. List this matter. Yes, Mr. Ratha, this and Mr. Mishra as also. This will. How do you put How do you do it?
29th July.
List this matter in the week commencing 29th July.
Mild.
Yes.
Item 8.
In the present proceeding, my lord.
No, it's is the cause of action. Does it survive?
Practically it doesn't.
Anyway, he wants to take time. Let him contact his client. As requested by learned counsel to the petitioner, is this matter vacation for what that? No, date.
24th July.
नहीं तो जून मासरे करना जून माने जुलाई रे फास्ट आडू करना
10th July.
10th July.
Item number 9.
9, my lord, it's a final disposal matter. Lords, I'm just beginning. Lords, starting. Lords,
नहीं start करियो जल्दी अपन end करियो नहीं कहीं start करियो
next week.
next week ना vacation. As requested by Sri A.K. Manthi, release this matter on
3rd July.
3rd July.
Item number 10.
3rd July कौन जून रो last आडू तो आसी वो
Item number 10.
I may plead a lordship.
Lordship seeking for an adjournment in the item number 10.
Wait. Who you are appealing for whom?
Opposite party number 3.
Opposite party number 3. Yes, Mr. Sharma, you?
I am for the management principal secretary.
So, Mr. They want time.
Clarity of
Vacation pore asu kete sunibe
again.
Everybody is in a vacation mood.
Sir,
But in final disposal matter, Mr. Mishra, I will request you to please come to the court physically. It will be even.
My lord, each day I am going because they are seeking time.
No, today it's all right. Today it's all right. Only for final disposal matters.
Consciously I have not gone because they are always taking time.
You are appearing for which party?
Opposite party number 4.
What is your good name?
Ankit Mohanty.
Ankit Mohanty, learned counsel appearing for opposite party number 4, request for an adjournment. List this matter.
3rd July.
Huh?
3rd July.
3rd July. On that day, be ready. No further adjournment shall be granted on that.
Item number 11.
This matter you received notice and again appear.
10 days before.
All right. Item 11. Item 11.
This is a matter related to termination. Peculiar lordship, kindly see the date chart I've given within the writ application.
Yes. Date chart.
Yes, my lord. Another small thing, my lord, I've given. Let's look at the writ application number 13637 of 2010. Your lordship is keeping, my lord.
You are also appearing in that case.
Okay, number 3, but I have not received any date chart.
No, I also am not finding any date chart.
All right, let it come next vacation after vacation. I'll give a date chart. Here is a termination. Thereafter resignation. They said I withdraw the resignation. No opportunity of hearing was given that they terminated my service. I will place it now.
All right, sir. Let us hear it after vacation.
After vacation.
हाँ जुलाई तो होगा. The Sri K.P. Mishra, learned senior counsel, submits that he had filed a date chart But the same is not on record. Sri H.S. Mishra, Learned Counsel, appearing for the opposite party number. Open number 3. Submits that he has also not received copy of the date chart. Let a copy of the date chart be served upon Sri Mishra.
Yeah, adjourn.
And be also furnished afresh for the court record. Place this matter on 10th July. 10th July.
No further argument, Malad.
All? It is very good.
He malantered today he is taking and he is restricting the future argument. Suppose I feel ill.
All right. It is made clear. It is made clear that no further adjournment shall be granted.
Obliged, Malad.
He is binding himself. All right.
Item number 12.
Item number 12, yes.
Maybe.
The petitioner in this petition just challenge the order passed by the Director Secondary Education, my lord. My lord, my main
Sir, upon the approval, kindly.
sir, my main ground of challenge is that my lord, director is not the competent authority to hear the appeal as per the 2000 government circular, my lord. My lordship has passed a judgment in that regard, my lord. Okay, lord.
Relying upon Justice Naidu's judgment.
Yes, my lord. Kedarnath Swami, my lord.
I have passed an order.
Yes,
Very recently I have passed. So this is a very recently I passed an order. This is on a different point.
Lordship may see the circular, my lord.
No, that I know. You tell me the facts.
Yes,
So there is an 83 circular followed by a 2000 circular.
2000 circular.
So then it all depends when the college came into the granted aid fold and when was it an aided institution.
Yes, my lord.
That we have to know.
Yes, my lord.
Had it been a purely private unaided institution, then that circular would apply.
Yes, my lord.
That is the position of law. Let us place the facts.
Yes, my lord. Well, here the petitioner challenged the order of the director dated 35/2011 passed by the Director Secondary Education, my lord. My lord, here, my lord, the OP number 4 was appointed against the asked 10 gazette post on 33/2005 by the managing committee, my lord. Thereafter, my lord, he remained on leave for from 2009 to 30/11/2009, my lord. My lord, in her termination vacancy, my lord, one Kadambini Mishra was appointed 12/4/2010.
Where is that order of your disengagement termination? 6/4/2010.
6/4/10 to 6/4/2010. My
Annexure
lord, number
6.
4 was terminated.
Annexure 6. OP number 4 was
Terminated, my lord.
It is you are appealing for OP number 4. All right. So against that termination vacancy, you are appointed.
Yes, my lord.
In that
No,
termination.
I am for the managing committee, my lord.
Okay. Managing committee has challenged.
Yes,
Okay. Who's for the other person?
Kadambini, nobody has appeared, my lord.
Notice has been made sufficient.
My lord.
Notice is sufficient. It's not.
My lord, Kadambini Mishra is not a party here.
It's not a party.
No, my lord.
Okay. No, my lord. Okay. Is she not a necessary party?
My lord.
Is
My lord,
she?
on the last occasion, there was a direction to our state council, my lord, that what is the present status of that management committee?
My lord, the managing committee which has filed this case is no more there. But
Yes.
my lord, my answer to that is managing committee is a perpetual body, my lord. My lord, had they have any grievance, my lord, they would have come up.
And my lord, as per the newly constituted managing committee, it is the Kadambini Mishra, the member of that managing committee and administration in charge.
And my lord, one important question, my lord.
No. Whether you can maintain the writ application anymore. Unless you have a fresh authorization. You are the secretary?
Yes, my lord.
This writ application must have been filed in the capacity of secretary.
The then secretary, my lord.
The then secretary.
Yes, my lord.
But if the after reconstitution, only a small formal resolution has to be passed probably. I don't know.
Whether the present managing committee is interested to pursue this matter?
My lord, we have written several letters to them, but they are not coming up, my lord.
Will issue notice? If necessary, no, we'll ask the state council to find out.
Already produced, my lord, as per the lordship direction.
Where is it?
Last occasion, since
Otherwise, it will become, oh, yes. It will become purely academic.
yes,
I have to say that Srimati Pratibha, opposite party number 4 is not continuing at Veera Vasanta Rautra school. from method till date.
And the copy of such newly formed managing committee, my lord, that also I have provided to both.
My learned senior supplied to me, my lord, and we have also written a letter to them whether they want to pursue this case or not. My lord, they have not given an answer, my lord. They are not coming up also, my lord.
So what will be the natural consequence of it?
My lord, I pray, my lord, let it come after vacation.
Yes, say that, because otherwise it will become a purely academic exercise which the court will not like to indulge in.
But the person, my lord,
The Swine Learned Counsel for the petitioner submits that instructions have been sought for from the managing committee regarding prosecution of the writ application, but no response has been received as yet. He requests for an adjournment. List this matter after vacation. What date? July. 10th July. On which date? Shri Swine tha usse tikhalta. Item 13. Balaram ko koi diyo.
May it please, my lord. This is the third round litigation of the petitioner. Earlier he was here.
This is being taken up for the first time or?
My lord?
Oh. No, is this being taken up for the first time? No, your lord.
No, this is earlier, before my lord, this is third or fourth time.
Before my learned senior starts, Lordship, this matter was listed yesterday. Perhaps, Lordship, in the meantime, the opposite party
by register post, fixing a short reasonable date, because it's be filed within 3 working days. Is this matter on 10th July? Yes.
This should come along with my lord WPC 20551 of 2021. 20551 of 2011.
Yes.
Item 14.
My claim in this case is, my lord, to get the grantinate, that is block grant, at par with the other employees of the institution at 100% instead of 60%.
Yes.
They file a counter, they have not disputed that. Rather, my case, I have given the copy.
Yes.
Where is the counter?
Already short copy. My lord, I am giving over the
online too.
e-file koti.
सीधा जोड़ी उनका
the judgment of my lord followed by another coordinate bench is covered, squarely covered this case.
When a DA files counter affidavit in the court, copy of which was has already been served upon learned counsel for the petitioner. The counter be kept under copy. On what judgment you are passing?
On similar identical issue in that Parvati Gade my lord's judgment. There the same person was terminated, reinstated. She was given 60%, but other have given 100%. My lord taken note of the law, directed that he should get it at par with others, 100%. Following this same, another Jasodagiri's case, another coordinate bench recently has also passed. That my lord's judgment has been followed.
Oh, this is in 2023.
Again?
This is in 2023.
Yes, yes. Taku follow kari ebe 24 mein sir order ta out deji tole. My lord justice Satpati no judgment. Same apan judgment follow kurche. Aw eta writ appeal apan judgment writ appeal confirm heji.
Ye what is Mr. Patnaik?
This is a copy.
Yes, my lord. Copy has been provided, but here, my lord, there are some factual differences. Here in this case, my lord, this petitioner was.
If you are ready with this,
Kali
kar do? Kali kar do?
Okay.
Yes, Mr. Das.
How is the judgment there? How should file this?
No, but what is the matter?
This petitioner was appointed as a classical teacher, Sanskrit teacher. He was terminated due to his familiar problem with the wife. He was arrested. Thereafter, he was terminated.
Okay.
So termination was challenged in the education. Sorry, that regional director of education, appellate authority, because at the relevant time it was honored. He was director to be reinstated in his former post. So he was allowed to continue. Join in the post in 2009. Accordingly, service was approved. But institution get granted from 1/4/2008. But the petition, all the employees were given 100% block grant. But my appointment was approved and by only 60% instead of 100%. The law laid down by my lord is that the institution, granted comes to the institution, not to any person. And moreover, there was no gap. The rule says that their rule says if the post was vacant for a certain period, then that period will not be counted for the purpose of granting it. But here there is no question of vacancy because my survey terminated, I have been reinstated. The same thing is in Parvati Ghadi's case. Same is also Jasodagiri's case. They were terminated by the effect of the regional director's order. They were reinstated. They are given 60%, 40%. What is there, my lord? My lord have directed. Then no, you will get it 100%. That is the only point. And my friend has filed the regional director's order also. I have not filed, he has filed it. Now in the council.
So you just go through, we will finish it tomorrow.
Our main stand, my lord, that when the order of rejoining was there, a reinstatement was there, my lord, the order was prospective in nature. And my lord, the benefit what it has been extended to him, it is to be calculated from that day. That order is very specific to that extent.
All right, place it tomorrow.
Yes.
Heard in part, let's this matter tomorrow.
Item 15.
So humble submission is that I am reporting for Utkal University.
Yes.
I am for the petitioner, my.
Yes.
My lord, in this case.
The last order you know.
Yes.
My lord, in this case, my lord, there is also a direction to the state authorities, my lord, to make our submission with respect to the pending decision to be taken at the level of the government, as it has been forwarded by the university authorities, my lord. My lord, I have received a message today, my lord, in the morning hour, that after in fact, my lord, that was not within their knowledge, my lord, and after there was a direction of this honorable court, my lord, they traced a file and they have not taken any decision in that regard, my lord, and they need only 15 days time, my lord, so that they will take a final decision under intimation with an affidavit. That decision has not been taken, and that is what, my lord, they have stated in my message. So, may I pray, my lord, in the reopening week, this may be taken up, and in the meantime, before vacation, my lord, I will try to file the affidavit. So
my lord, the letter carries, in response to your letter cited above, I am given a letter by the university. I am to inform you that presently the authority in the university has withheld the payment of salary to the teachers on superannuation against the EL earned in lieu of days of rostered duty performed while in service. This will be taken into consideration only after receipt of the decision of the. My lord, this letter is 2013. Now we are in 24, my lord. I am a retired professor, my lord.
And my lord, not only that, my lord, the
More than
counter
30 years
submitted by the university also speaks so.
Yes, yes.
The counter submitted by the university, my lord, in the previous occasion by the previous council. They are also, my lord, they have stated that it is pending with the government, and my lord, when I went through all the documents and after with a copy of the lordship's order, my lord, I forwarded the same to the department, and now the department is taking only 15 days.
This will be hit by delay and laches. The court cannot give a premium to this.
Yes.
You have not taken a decision for as long as 11 years. The court will not permit you to take that. You may take, it is up to you. But you have not taken, you have not taken, that's all. Whatever is the basis of the petitioner's claim, that will be considered without the decision of the government. Yes, place your matter.
My lord.
This will send a very bad signal to the to everybody, to all concerned. 2013,
yes.
The representation, no action was taken. So that is the factual aspect which this court will consider. Yes.
My lord.
What is your case?
My lord, I am a retired professor in psychology. I was appointed from 3rd 11/1973, and I retired on superannuation at the age of 60 years on 31/1/2008. My lord, after several rounds of correspondence, they refused my EL, and in the year 2013, my EL was considered, but my roster duty EL At hand, they restricted admitting that some roster duty EL as pending, but not up to my satisfaction. I under RTI, I collected the all service book particulars and then reprinted them, and then they are replying that government has suspended this matter. My lord, several other employees, they have also been paid EL on roster duty. That also the university has not controverted in their countermeasure.
Where have you said that in your writ application?
My lord. Paragraph 12, my lord, running page 6 of the writ petition.
Yes.
The several other teaching and non-teaching staff after retirement has been paid unutilized on-leave encashment, including for the roster duties performed during vacation.
Yes.
Here, my lord, I have totally Dr. Biranjan Narayan Pohan, one retired professor in Department of Psychology.
Yes, you have given a list. I've seen that list.
My lord.
So this has not been
controverted by the university, my lord. And after examining the documents and RTI, my lord,
no, they have replied like this, that in reply to arguments made in paragraph 12 and 13, it is submitted that disbursement of pensionary benefits to retired employees are being made after verification and recommendation of the local fund audit deputed by the state government. In this instance case, the audit being recommended for encashment of 129 days of EL in respect of Dr. Manti, and this office issued the office order accordingly. So you claim it to be 152 days. You claim it to be 152 days.
No, my lord.
So roster, my humble submission is that the roster duty, according to him, is 457 days, and is compared to the EL in respect to 157 into 1/3, it comes to 152 days. He claims for that 152 days. My humble submission is that the auditor, which is assigned by the government of Orissa, according to section 23 of University Act, the audit of accounts, he didn't allow. He raised the objection. Prior to 96, the university professor or teachers or associate professor whether eligible or not to get the roster duty in respect to EL.
No, is the audit is the auditor superior to the university? Audit can make only a recommendation. Audit can audit can only make a recommendation that is to be considered by the syndicate.
I guess humble submission, wrongly I placed the word. So thing is that due to this point arise by the auditor, the university what will take they give a letter to the higher education department to get the clarification whether up to 96 the roster duty is converted to the EL. So already 129 is disbursed. 129.
That I have seen. 129 has been disbursed. Where is that audit? Finding?
The audit finding the over phone yesterday when I went to their office, I saw the order is mentioned in the order sheet. So in 2008, university sent the letter to the higher education for remindation. Again on 25/5/2008, they also again sent a letter to give the clarification whether the teacher get the EL in respect to the roster duty, sir.
No, what about those the list of teachers, the list which has been mentioned in paragraph 12 of the writ application? You have not denied it.
No. In the humble submission is that in respect to the counter, they didn't mention about this. Only they mention 129 is disbursed. If government will allow so balance should be disbursed. That is the.
So here Article 14 comes into play. Does it not? You have given, admittedly, as per paragraph 12 of the writ application, around 6 teaching staff have been given the benefit of calculation of EL, including roster duty.
Yes.
Now, the petitioner claims to be standing on the same footing. You have not specifically denied this averment in your writ application, in your counter affidavit.
Okay, sir.
So obviously Article 14 would come into play. You have taken the plea that we have written to the government seeking clarification.
Humble submission, we are not taking plea. The fact is that when it is arised by the auditor, the section 23 is as per the University Act, when audit arise this thing on that basis to get the clarification, if the government gave the clarification, so they will provide all the balance.
So the government will sleep for years together, which is now 11 years have passed.
No, this is not okay. The university already.
Sir, please listen. Sir, please, you have not allowed me to complete.
Oh, sir, sir.
Now the government sleeps blissfully for 11 years. The retired employee will run from pillar to post.
No, this is not.
Because the university has sought for clarification from the government. The prima facie materials are there to see, to persuade this court to hold that Article 14 is violated. So why not the petitioner will get the benefit? What audit will say something and you will refer to the government. Government will take 11 years to even dispose of the writ application or the representation. Even today also, the State Council requests for time that we will dispose of the matter.
My humble submission will take, your honor to take what, according to that will proceed.
Nothing. End of the matter.
My lord, audit objection they are telling, here is their letter under annexure B/2 running page 53 of the
Yes.
Here, I am director, registrar is writing a letter to the deputy secretary government. I am directed to inform you that the university teachers had been availing on leave in lieu of roster duty performed during the vacation. That is one day.
Just one moment. Sir, just one moment. Just.
So how audit?
I can just put 1 minute. Are you actually disputing the fact that he had performed a roster duty during vacation?
No, sir. It's a fact.
Yes, please.
They have also calculated the days.
Bit by bit.
They have also calculated the days even.
My humble submission is that.
So what remains? Nothing. 8 Sarava. Podun. B/2.
Subsequently, a circular has been issued as per orders of the Vice Chancellor by number so dated 10th May 96, copy enclosed. Regarding this copy letter, they have not enclosed. Copy enclosed regarding the formula for calculation of the earned leave in lieu of roster duty. In the said order, it has been clearly stated that the practice of crediting EL to the EL account against performing of roster duty was in vogue in the office. But the basis on which such practice was being carried out is not available for reference. UGC leave rules for teachers of universities issued on 14/1/2005 at item number 5B specifying for according EL for 1/3 of the period, if any, during which he is required to perform duties during vacation. It is therefore requested kindly to communicate the clarification as to whether the teachers performed roster duty during vacation period 96 will be eligible to get the facility of EL against the roster duty. Since the retired teachers are pressing hard for sanction of unutilized leave against their EL as credit, and the same will be finalized in accordance with the views of the government in this connection. And hardly question, this is year 2008, my lord.
Yes.
Well, next page is 54, that is 26/5/2008, my lord. Then they paid others, my lord, but arbitrarily and in gross, I have been harassed, my lord. Fortunately or accidentally.
All right, I would like to see this UGC leave rules.
My lord.
Do you have a copy of that UGC leave rules?
That is, I have given in my rejoinder. That is.
Copy of gazette notification. Very good. No, this is something else. Where's the UGC leave rules? They have referred to that.
Yes.
Mr. Patnaik?
Yes, ma'am.
Do you have it?
I have not given anything, my lord. But I think, my lord, that has been referred to.
No, we can get it from the our High Court library. We can get it.
Running page 119 of the brief.
119. Teaching days. No, they are referring to Rule 5. This is not a rule. This is just a revised guidelines.
Here is they have stated that the university teachers may be credited with the 1/3 period of the earned leave. However, the college may have an option of total vacation. So
କୋଉ ଜାଗାରେ ପଢୁଛନ୍ତି କୋଉ ଜାଗାରେ ପଢୁଛନ୍ତି
my internal page 66 and that is 119.
yes
Third line. Leave except when asked to work during the vacation for which, as in the case of university teachers, 1/3 of the period will be credited as earned leave.
except when asked to work during vacations for which. So that he has performed roster duty during vacation is not disputed by the university, as Learned Council has very fairly submitted. He says that it's not disputed. So that part is taken care of. Now the question is, I'll just want to see that rule. What is that rule? That UGC leave rule. Huh? So can you produce it? Or we'll ask the library, but you also find out.
I can get.
Do you have a copy of that? You must be having a copy of that rule.
No, sir, I have no.
You are applying for the university. How can you not have a copy of that rule?
No, sir, I have to. I'm going through the net. I'm submitting the facts, sir.
All right.
They have been paying and
All right.
others.
All right. Heard in part. Please this matter tomorrow. Then State Council is requested to furnish a copy of the UGC leave rules for perusal of this court. It will come tomorrow. We'll complete it tomorrow. As referred to, UGC leave rule for teachers of universities. UGC leave rule for teachers of universities. Library
Sir.
tomorrow we'll finish it. Yes.
I do not 16.
16. Petitioners are the lecturers. I mean, VC method.
Yes. Final disposal matters are very difficult, sir. Mr. Sharma. Final disposal matters in VC very difficult.
But this is a very simple matter.
Maybe simple for you, sir. It will be very, very difficult for me to understand.
Then your lordship may adjourn.
Kont.
The petitioner 1 to 5 are retired in the meantime 6, 7 are
Stepping up, antedating your pay, simple.
Because the annexure 1 series is the approval orders. Annexure 2 is the pay fixation statement of the 6th pay commission. The petition pay fixation statement, the date of increment of the petitioner fixed from 1/1/2006.
You are Prakash Chandra Panigrahi.
Yes, yes, for all the petitioners. 7 petitioners are there.
Okay.
Millard, kindly come to Annexure 2 series, that is page 19.
Yes.
This is pay fixation statement as per the 6th pay revision rules. Here, the date of increment, next page 20, column number 14, date of increment 1/1/2007.
Yes.
They fixed from 1/1/2006 and then increment to 2007. All these 6 petitioners are same. But kindly come to Annexure 3, page 32.
Sunil Kumar Patnaik.
Yes. He's a junior to the petitioners and his pay fixed from 1/1/2006, but his date of increment is fixed from 1/6/2006.
Junior, you are saying that he is junior, but
Yes.
on what basis are you saying what is his date of joining?
His date of joining must be 1/6.
No, on what basis are you saying that he is junior to you? Is he junior when after he joined after your joining, or is he placed below in the gradation list, or whatever?
After our joining.
So where have you said that? That he is junior to you?
That is not there. But his date of joining.
No, because you say in paragraph 5 of your writ application, paragraph 6, that it is respectfully submitted here that though Sri Sunil Kumar Patnaik working as a lecturer in chemistry in RCM College, Kalikot is junior to the petitioners. So that we want to know how he is junior. On what basis are you saying that he is junior? Let us see what is the reply. Para 6.
That reply is not.
Para 6, there is no reply.
There is no reply. Kim Janiva is junior bully?
Then I take instruction.
Court basis is junior, Mr. Sharma. This is your basic case. Your case rests on your pay will be stepped up or antedated to that of your junior, provided that he is your junior. So you have to first establish that he is your junior. On what basis? He must have been appointed later than you, or he may have been, or even if he is on the same date, then he may have been placed below you.
He was he's appointed later the appointment of the
ঠিক
petitioner.
আছে সেটা আপনারা কইবেন না কেবে appointed হলে কোন how do we know that he is junior? That is the foundational fact. We take it up next week.
Yes, Lord.
Next week রে ଦେଖିଲ এই ବୁଧବାର ପାଠର ମ୍ୟାଟର ଅଛି
17th class.
ଗୋଟେ ଅଛି. But in part is this matter on 15th May. Yes.
Item 17.
এই যে লেখନ୍ତୁ Sri Sharma, learned counsel for the petitioner, shall satisfy the court that Sri Sunil Kumar Patnaik, the person against whom the petitioners claim stepping up / antedatation of pay is junior to them. Yes.
Minor 17.
Just one. Call it. Setting up antedation of pay is junior to them. Yes.
My lord,
Yes, Mrs. Jana.
Your lordship, may kindly allow me to conduct this case.
Please. Please.
My lord, the petition has been filed with a prayer to consider her case to be appointed as a Shiksha Sahayak pursuant to the advertisement that Annexure. My lord, Annexure 1 advertisement was issued for appointment of Shiksha Sahayak. So petitioner along with others, they have applied online. Application was thereafter a short list was my lord prepared, and in the short list I have given the preference, 5 preference has to be given. I have given preference Puri number 1 and thereafter other 5 preference. My name has been enlisted in the draft list prepared by the authority.
Where is it? Where is draft list?
Draft list, your lordship may kindly turn to.
What is your name?
Name is my lord Kalyani Sethi. Kalyani Sethi, my lord. Your lordship may kindly turn to.
Yes, I got it.
Yes.
Serial number
page
26.
32.
Serial number 26.
130. जोटा 32 अच्छी पेज 32 देखिए.
Page 32.
पुरी डिस्ट्रिक्ट ऑफ पुरी.
अच्छा.
आरंभ होइछि पेज 29.
Okay.
Page 29.
Page 29 is the online application.
Online application.
Draft list.
हाँ.
Is Annex 3. All right.
हाँ.
So you are placed at serial number
130. Page 32.
130. Okay.
My lord. Thereafter, my lord, at that point of time, I was having only BA qualification. I was continuing as in the B.Ed, and I have given an order taking that I have already given my examination is over.
OTAT.
No, B.Ed.
BA.
So my examination is over, but on getting the certificate, I will produce it. I have given an undertaking, but I have been selected as an untrained candidate. Thereafter, the final list was prepared. I was posted at Bhadrak, where there is no post for the women SC candidate, although I have given option for the Puri. At Puri, 7 posts were lying vacant, but I have not been considered to be appointed at Puri. And thereafter, they have another advertisement was issued that by virtue of the direction of this honorable court, that the person, those who have overage, they can apply. I have applied,
But you were already, but you did not join in Bhadrak.
I could not, because at Bhadrak, there is no post of women scheduled caste candidate.
You could not means were you prevented or what happened?
There was no post, my lord.
Nevertheless, it was up to them. They have
They didn't. So
they did not allow you.
No. When there was no post, so I could not.
Let us see where is your where is the direction to you to join at Bhadrak?
My lord,
ভদ্র কথাটা কোড লেখা আছে where is it?
কথাটা লেখা আছে। My lord, they have given the counter affidavit stating therein, your lordship may kindly turn to their counter. Counter page 2. She has given. Huh? Question? Yes, page 4. Page 4, para 14. That in response of the said corrigendum, paper upload the eligibility list, those who have applied for the post of Shiksha Sahayak in 4th preference. District of Puri and first preference of overage candidate for the year 2014. Total 92 posts of class 3 arts trained on trained candidate list downloaded from the OPEPA website where the name of the petitioner is not placed in the said list. Your lordship may kindly.
No, the line very interesting.
Yeah, yes. In the said list, merit list, by office order number so and so Puri.
No. Duty podile, where the name of the petitioner is not placed in this list.
And the petitioner opted fourth option in Bhadrak district. So the name of the petitioner might have, that I have underlined.
Underline
Might have placed.
What is the meaning of might have? What sort of counter is this, Mr. Patnaik?
Para number 7, my lord, of the read. No, it is a district project coordinator. It a Puri je file kale. With respect to the allegation in para number 7 of the writ petition. That it is submitted.
He claims what I find is your statement that you were posted at Puri at Bhadrak against a non-existent post. That doesn't seem to be borne out from the record.
Para number 7, that is where
para 7 of the writ application.
Writ petition. Page number 5. That it is submitted that name of the applicant was placed under the 4th preference district Bhadrak under SC women category for the post arts. As the petitioner already appeared in the B.Ed examination, so she had given an undertaking to the opposite party number 5 dated 11/2012 along with the B.Ed admit card.
11/12/2014. It has been corrected as 11/12/2014. May not be in your copy, but it is.
I'm not. She may be allowed to submit the B.Ed certificate after publication of the result, the copy of the draft list of the 4th district, fourth choice student, 4th preference district, and the undertaking the applicant is enclosed and it's a 4 and 5. So while replying to this one, though there is no specific para-wise reply, my lord, but I found, my lord, that the DPC Puri, by disputing the claim of the petitioner with respect to Puri, with respect to Bhadrak, because
so what was the what is the actual status?
Yes, ma'am.
She had applied. Let me just understand. Correct me if I'm wrong. So she had applied.
Yes, ma'am.
She did not have BD qualification.
Yes, ma'am.
She submitted an undertaking that I will supply the.
Yes.
So there was her name was placed in the draft list initially under
130.
No.
130.
But in Annexure 4, what is Annexure 4? This is a list of eligible applicants for.
Preference of Bhadrak district.
That does not mention. Code will likha. Bhadrak khali likha. So Bhadrak she was placed at serial number 26.
Yes.
Now it is said that there was no post available for her.
Online application for engagement of Shiksha Sahayak. My lord, first district preference, Puri.
Puri, Khordha, Ganjam, Bhadrak.
Yes.
Tapare Koraput.
ମୁଁ 5ଟା ଅପସନ ଦେଇଛି
so ଆପଣ ପ୍ରତ୍ୟେକ district ର what is the method then? Every district there will be first preference जो ମାନଙ୍କର ପୁରୀ ଥିବ ସେମାନଙ୍କର ଦେଖାଯିବ ଯୋଉଠି କଟ ଅଫ ଡେଟ୍ ଭିତରେ ଯଦି ଆସିଲେ ଭଲ କଥା ନହେଲେ କଟିଗଲା ପୁଣି ସେକେଣ୍ଡ କୁ ଯିବ ପୁଣି ଥର୍ଡ କୁ ଯିବ ପୁଣି ଫୋର୍ଥ କୁ ଯିବ ଏମିତି ଆଉ କଣ
ଏବଂ ପୁରୀରେ 7ଟା ପୋଷ୍ଟ ଖାଲି ଅଛି keeping that in view your lordship was pleased to pass an interim order keeping a post vacant.
Vacant.
Yes.
So we need a specific counter here. Isn't it? See, what does the counter say?
Our counter says, my lord, that since that petitioner didn't have that particular qualification of B.Ed as on the date of the last date of submission, there was no scope for the authorities to accept any undertaking. But there was no reason to reject her candidature only because there is also a provision for the untrained persons to apply, my lord. So the candidature of the petitioner was considered as an untrained candidate. Now, with respect to the vacancies which are advertised in that particular Puri district, my lord, the total number of posts which are in the first preference category, my lord, all the posts were filled up. Only one person, my lord, she didn't join. As against the same, the another person, my lord, from the pool, on the basis of the merit under that particular category, she was also accommodated in that particular post. So since this particular petitioner had not the B.Ed qualification and no person securing less mark in comparison to the petitioner with as untrained candidate.
It means she is secured below the cutoff mark.
No, no. One person has been appointed as an untrained teacher, is Shiksha Sahayaka, who is less, who has secured less mark than me.
Who is he? Where have you said that?
That has been, I have stated in my lord rejoinder.
You come to paragraph 10 of the counter.
Paragraph
Paragraph 10 of the counter. As per merit, 7 numbers of SC open and 3 numbers of SC F mark on female. Having training qualification candidates was placed in the merit list and cutoff mark is and the cutoff mark is in respect of SC F category.
Accordingly, after verification of the testimonial at DPO,
We are not concerned with that.
No, my lord. Thereafter, my lord, para number 11, that after issuing the engagement order, one Surekha Bala Behera from SC female category during application or didn't join, my lord, in our post. As a result of this said post was lying vacant. After that, the said vacant post has already been filled up by another person, my lord, Jali, during application number 1, who was placed in the merit list as SC female untrained category.
So here they say that the next paragraph, the petitioner Kalyani Sethi has secured less percentage of marks than the untrained candidate Krishna Priya Jali.
That is what, my lord.
Annexure 8/4 let us see.
Turn to page
8/4 से लिखिले कृष्ण प्रिया जाली 158.931 petitioner केते कहलेनी
ना
petitioner ता पूर्वर को आइछ ना
कहै पूर्वी
काई
आपण रिजल्ट कोन कहली
हमर रिजल्ट अछि आपण पेज 3 टा देखंतु पेज 3 para 30
मतलब in the para number 5 of our counter, the petitioner neither submitted B.Ed certificate nor filled up the said column in her application. As a result, she was treated as +3 arts untrained candidate, secured 86.3690.
Yes. Your lordship may kindly talk to, in answer to that, your lordship may kindly page 3 of my rejoinder, para 30.
Where have you said that? Koti paragraph kete kali?
Paragraph 5.
No, before that,
which para number 5?
5.
Para number 5 of our counter.
86.3. How have you replied to this?
My lord, your lordship may kindly turn to page 3, para 13 of the rejoinder. It is submitted that OP number 4 has issued appointment order in respect of Krishnapriya Jali, SC, who has secured more percentage of mark than the present petitioner. But here the deponent has suppressed the fact that after issuance of the engagement order in respect of the Krishnapriya Jali, further engagement order has also been issued in respect of one Gunanidhi Bhoi under arts untrained category on 28/3/16.
SC पुनी bracket UR category कोन SC bracket पुनी UR category
Sir, you are
SC पुनी UR category
SC.
हां अच्छा who has secured 83.05 which is less than you
as per the final yes who is less who has
अच्छा यार रिप्लाई से कोन देले
आउ देना
नहीं ना थी देबे ना नहीं दीजिए ना
and another thing
wait से दीजिए ना the pertinent to mention there were 6 posts of lying vacant meant for +3 arts. The state project office provided that the eligible list of candidates for fourth preference district in which Sri Gunanidhi Bhoi opted his first option over age as Puri district in his online.
My lord, that is with respect to the second advertisement when the overage persons, my lord, they were allowed to participate in that recruitment.
My lord, assuming that is so, my lord, in the first preference, so far as first advertisement is concerned, the post was lying vacant and I was eligible why they have not given me appointment? Instead, they have waited for the second list.
My lord, to that extent, my lord, our counter is very specific. In Puri district, the total number of vacancies, the persons who were offered with appointment, and only one person did join. And against that particular post, my lord, another person has already been offered.
Krishna Priya Jali.
Yes, ma'am.
All right. Krishna Priya Jali has more marks than
Yes.
the petitioner. All right. What about Gunanidhi Bhoi?
So that we clarified in our para number 4, my lord, that it is with respect to another advertisement.
Overaged.
No.
Overage candidates.
Overage candidate.
And that is second advertisement.
Yes.
So by that time, I was very much available. Why they have not given me the appointment?
The subject to a condition, my lord, that select list also must be valid, my lord, during that particular period. Because once the posts have already been filled up,
And-
there is no question of remaining validity of that particular select list. Only one post, my lord, remained unfilled because of non-joining, and that particular post has also been filled up.
My lord, but right now, in view of the interim order passed by this honorable court, on the fact that the 7 posts are lying vacant and 1 post has been kept.
Can she not be adjusted?
I have no instruction to that.
All right. Heard in part. This is Sujata Jena, Learned Counsel appearing for the petitioner, submits that after completion of the process of recruitment pursuant to the first advertisement, she was left out on the ground of non-availability of vacancies. However, the authorities allowed one Gunanidhi Bhoi to be appointed, though he had secured less marks than the petitioner. In response, Sri Patnaik Learned State Council submits that said Gunanidhi Bhoi was appointed on the basis of the selection conducted pursuant to the subsequent advertisement for overaged candidates. So, be that as it may, fact remains that there were vacancies available at the time of issuance of the second advertisement. So, the question is if the petitioner, having been selected in the first selection process and had more marks than Gunanidhi Bhoi, why was she left out? Why was she not considered? Stop. The parties shall address the court on the above issue on the next date of hearing. List this matter. Vacation पर करो यार. Vacation पर करो. ये आरो week रे ही
Hard
period.
in part, हाँ ठीक है.
आरो week रे judgment ही
नहीं
period.
नहीं ठीक है. Hard in part.
Reopening week रानी बा.
हाँ तब.
ही period.
Sir, 26 June.
26 June.
Yes.
Item 18.
Mobilize.
ठीक है. हो गया. तू मुझे खा.
Four changes.
Sorry. Sir, 26 June, not 3rd July. Because I have to get the.
Tell Mrs. Jena. Okay. 3rd July.
And he continued with the particular job till end of 2018. And from the month of January 2019, from 1st of January 2019, because of the fact that she has married woman and she has tried for a baby, it was not materialized. With permission from the base level authority, she went to Raurkela, where she has operated because of the IVR process, and it was a lengthy process and it requires a total rest in the particular hospital for a longer period, and that I have also annexed the court as annex number 2, all the medical document. And because of the fact that in the process, because of his ill fate, the baby was not materialized, and in the month of July, it was not materialized, and thereafter, the first week of July, it was found the miscarriage was there, and she, after 10 days rest, she was advised to go and to take join, and accordingly, she has joined in the month of, tried to join in the month of July 2019, my lord. By then, my lord, it is their case that they have given some so-called notice, which I have not received, and also they have issued a paper publication notice. It was on 30th July 2019. That is their case. They are on 30th July 2019, a Nirdisha that I was found absent, and they have also directed me to come and join within a period of 7 days. So from the date of publication of the notice was on 30th July 2019, wherein they have directed to come and join me by 6th of August 2019, my lord. And 2 days thereafter, it is their case, they have dismissed me. I don't know, because in fact, at least a month time is required to enter the process. But whatever it may be, it is their case that on 30th July 2019, they have issued the paper publication notice. On 6th, with giving me a time of to there, I have to report by 6/8/2019. Otherwise, I will have to face the consequence. But whatever it may be, just 2 days thereafter, they have dismissed from the engagement matter. And because of the fact that I have not received anything, I approached the Hon'Ble Court that even though I am trying to join, I have not been joined. This Hon'Ble Court directed me to go and approach the concerned sub-collector. I approached the sub-collector. Sub-collector has also taken note of my entire reprehension. He has dismissed the same. Thereafter, I approached this through an appeal. I preferred an appeal before the concerned ADM appellate authority, and wherein my stand was clear to the Section 3 stance that because of the maternity leave, I was constrained to take leave, my lord, and because of the fact that I have not been given an opportunity at any point of time, any notice has been served to me, and this paper publication, which was made on 30th July 2019, gives me the period of 7 days, but just a day or two thereafter I have been shown to be dismissed, and this dismissal order has not been served to me, and my absence in the particular thing is not a genuine one. It is a genuine to this extent that because of intimation with the authorities, I have remained absent. But on 3 ground matter, the sub-collector in a very cryptic manner, page 22 of my brief matter.
Let us come to the order of the ADM then. ADM was better.
Page 22 matter.
Page
27 matter. I'm sorry, page 27.
27 is the
appellate order.
Achha.
Appellate order.
It is decided with the following observation. Kindly place it.
My lord.
1.
My lord, may I pray just to have a glance to it starts there because by my contention is at the top. It reveals from the written statement of the appellant that
page
top page 27 ekdam top first line, my lord.
Yes.
It reveals,
yes.
It reveals from the written statement of the appellant that she has performed her duties till 1/1/2019, my lord.
Yes. On submission of leave application.
Again, on submission of leave application, she submitted joining report on 12/7/2019 after declaration medically fit. Further, the applicant submit that she has received stock on 28/10/2018 and 8/12/2018, and namely has also been transferred to account of Anganwadi worker for purchase of food stock during this period. The appellant has also denied regarding non-responding of the official letters. So thereafter, as regards of obtaining of medical documents, the appellant has submitted she was undergone medical treatment at indoor patient under Dr. Munnu Patnaik MD, adjudicating the submission of CTPO Khariar and appellant Gayatri Meher relied documents order of sub-collector Nuapada. It is decided with the following observation. First one. It is a fact that the appellant has availed unauthorized leave. It is a regular process of ICDS officer that amount is transferred regularly to the account of Anganwadi Center in each and every month for purchase of food stock. The person who was working in the absence of the appellant, she was purchasing the food stock. Hence, the document cannot substantiate the presence of appellant Srimati Gayatri Meher. The appellant was remain absent from the month of September 2018 till disengagement. The appellant further submits waybill dated 28/10/2018 and 8/11/2018 respectively to prove her presence in Anganwadi Center. But it disclosed that she has submitted forged document of WB on 8/11/2018. The receipt itself is evidence it proves that in order to substantiate her presence in the Angawani sector, she has managed to obtain this forged document. Second, submission of medical document from a private clinic is not acceptable as per government provision. If the medical certificate is genuine one, she would have authenticated the said certificate by countersigning the same from CDMO Nuapada. This has not been done. Third, which is important one, only she has said sufficient opportunity has given to the appellant before dismissal from the post. So my humble submission, she has accepted to the fact that till 2019 first part, that means to the end of 2018, my lord, this process was on and each and every, it was running in a smooth manner because money has been given. I have purchased the food stock with due permission and my lord knows.
No, you must tell when did you avail leave?
Leave from first, my lord. I've said specifically said so. My lord, 1st of January 2019. Para 5, my lord.
What, you went on leave?
Yeah.
You intimated to whom that you are going on leave?
My lord. To my, so my lord, the supervisor, my lord, who is immediate boss to me.
In writing?
My lord.
Do you have a copy of that writing?
But that I have the copy in the appeal, prepared in the appeal, but they have said that, and there it also put the my lord, found the signature of the CDQ.
You were admitted to the hospital on 4th of January. You were discharged on 12th of January. Then what?
What? January, my lord. As my lord knows, IBR process is a complicated process.
No, tell me.
So in my lord may see my medical report.
No, I've seen that. I'm from the medical report itself. I've got all these dates.
July, my lord.
In July.
It was ended in, my lord may see page 17.
Page 17.
26. It continued each and every day. Page 16, each and every day, 5-1, 9-5, 16-5.
So in between this date of discharge till June, you were under treatment. The thing is that you don't seem to have intimated the authorities.
No, my humble submission, my lord, kindly appreciate, my lord. It is their specific case that on a particular date, on 2-3 occasions, their authorities has visited me, and it is also their case that they have intimated my authorities regarding all such aspects.
देखो ସେମାନେ ସେ ଯୋଉ କାରଣ ଦର୍ଶାଅ ନୋଟିସ ସେମାନେ ଲେଖିଲେ ପରିବାରଙ୍କ ପତ୍ର ସଂଖ୍ୟା ନମ୍ବର 22/10/2018 which is prior to your going on leave. Then 2/2/2019 which is after, again 12/3/2019 ଏବଂ 9/4/2018 9/4/2018 ଟା 2019 ହବ ଆପଣଙ୍କୁ କୈଫିୟତ ମଗା ଯାଇଥିଲା। ଆପଣ ଯୋଉ କହୁଛନ୍ତି that you went on leave on 1/1/2019 but there seems to be a show cause notice issued prior to that date which is on 22/10/2018. Why was that issue?
My humble submission, all these things has been planted because of the fact that nothing has been solved to me. And when I approached the concern of this Hon'Ble court, and this Hon'Ble court directed me to file a repension, although I filed the repension, but Hon'Ble court directed to file a better repension before the sub-collector, and that is the reason for which these things has been planted.
Let us see the sub-collector's order.
Let me see.
Sub-collector order is not visible.
I will place it, my lord, although I am sorry. It starts from page 19, my lord. Aggrieved upon the disengagement order passed by sub-collector, no appeal which was communicated to the
Agreement passed by sub-collector Nuapada.
Nuapada, I'm sorry, Nuapada, which was communicated to her by order number such and such dated 9/8/2019 of CDPO Khariar. The applicant approached Hon'Ble High Court through WPC number such and such. Hon'Ble High Court, the order that disposed of with writ petition directing the opposite party number 3, sub-collector Nuapada, to take a decision on the repension filed by the petitioner to dispose of the petition of the appellant, Srimati Gayatri Meher. She was called upon for hearing on 22nd 10/2019, heard her and took deposition of the appellant. The appellant stated that she was on leave from 1/2019 to 1/7/2019. In support of this, she has also submitted application claiming that the said application was received by CDPO and put her signature on it. She has also furnished supporting document, that is discharge summary of Shakti Memorial Hospital, Raurkela, and subsequent follow-up treatment from 28/1/2019 to 26/2019. Being lady worker, she has the right to get motherhood. Accordingly, she ought to seek permission from immediate authority. Instead of doing so, she neither left. She left. She left Anganwadi center without intimating or applied leave. The authority or not applied leave.
So he does not believe your leave application. The application claimed to be submitted under supervisor signature was a fake one. How?
It is. The application and the application claimed to be submitted under supervisor signature was a fake one. The statement of lady supervisor such and such already disengaged
had not submitted any
leave application to her. She has not signed in the body of application claimed to be submitted by the Anganwadi worker. She has forged the application after the disengagement.
Finding out how do you overcome?
My humble submission, my lord. The particular lady supervisor to whom I have submitted, my lord, it is she has her statement has not been according to that.
The statement of lady supervisor Damayanti Jena is that Srimati Gayatri Meher, you had not submitted any leave application.
My humble submission not been recorded. I'll come to later.
No, if that is the case, then we have to call for the file.
And one more things, my lord. Thereafter also me permits I can place it. Admittedly, entire thing has been cropped up, my lord, after this particular notice. My lord. Notice was issued on 30th August 2019. Admittedly.
Sub-collector, when the sub-collector says the statement of lady supervisor, you say that it has not been recorded.
My lord.
Then one has to see the
obviously. And my humble submission, everything, whatever is there, this there's a notice of everything, my lord. All these things has been prepared only after that. Because the Honorable Court has interfered, Honorable Court has directed.
Heard in part. Sri Manas Chand, Learned Counsel for the Manas Kumar Chand, Learned Counsel for the yes.
May I suggest one thing? Under the rules, I find that in case of removal, it's a case of removal. Disengagement. Is the collector who is the appellate authority in case
under the 25/2007.
Yes. Lordship may kindly refer
It is
to
with
this.
respect to selection, my lord, it is ADM.
ADM.
But with respect to disengagement, a specific provision is there that collector will take.
Against the order of the ADM?
No.
No, ADM no. Against the
It is
order
called
of
She approached this court. This court could have directed her to file an appeal before the collector. Instead of that, probably it was never pointed out. So this court directed it to be to the sub-collector to take up the appeal.
In so much of material to be gone into your lordship may
is
direct.
actually the person who is responsible for selection.
At this stage, at this distance of time, again relegating her to the collector, because you see, the sub-collector must be deemed to be that authority as per the rules because of the direction given by this court.
The sub-collector is the chairman of that committee.
Sub-collector should not have been directed, but anyway, I was very surprised initially that how
ADM was there.
first line ta paduntu agya.
ADM order pass karche.
Apna agya sub-collector first order ta paduntu. Aggrieved upon the disengagement order passed by the sub-collector Nuapada. She went to the High Court and High Court again directed the sub-collector Nuapada to. So it is as if he's judge of his own cause.
Thereafter, my lord, the ADM has been taken.
Nemo judex.
What has happened, my
causa
lord,
sua.
because it is my specific stand before the Honorable Court that nothing has been issued, well, solved to me, even the disengagement order. That's why the Honorable Court has said, go and file a representation and let it be considered.
That representation was probably should have been directed to be filed before the collector. Anyway, this court has passed that
And
order. We have
this court has directed this. Since the petitioner has appropriate appeal remedy, the writ petition is not entertainable at this stage. In a disposal of the writ petition, the court permits the petitioner to file appeal before the appellate authority within a period of 7 days, and thereafter the
So appellate authority court କହିଛନ୍ତି ଆପଣ appellate authority ପାଖରେ ନ file କରିକି sub-collector
let us accept, my lord. I do consider that the appellate authority come ADM, that is the specific. No. My appeal memo has, my lord, because of that in the code of appellate authority, come additional district magistrate, no approach. It was there. My humble submission is, of course, let us accept that because of ignorance or anything else, but yes, fine. What has, my lord, left the authority not to take it properly? If there is
that matter can be dealt with by this court. That matter, notwithstanding that fact, this court can assume jurisdiction. This is not an issue. In 226 plenary power, the court can always take up. But what I would like to do is, I will ask you to produce that file.
As your lordship.
If there is a statement recorded, then he has no case. If there is no statement, then he has a case to argue.
One aspect, and the subsequent aspect that I want to press with on the court, that admittedly the notice, paper publication, it is their effort, my lord. It was made on 30th July 2019, wherein it has been said, come back within 7 days or face the consequence. So the 7 days, it starts from 30th July 2019 till 6th August 2019. So the final order has been passed on 8th August, 2 days after. So whatever they, my humble submission, whatever they did, it is just a paperwork. Admitted, this part is admitted, they cannot deny it. 30th July 2019, 8/8/2019 is my dismissal order.
Anyway, the current part, Sri Manas Kumar Chandra and counsel appealing for the petitioner submits, referring to the order passed by the sub-collector under Annexure 4, that the statement of the supervisor, Damayanti Jena, was never recorded, but mentioned so in the said order. In order to appreciate this contention, it is necessary to peruse the file, peruse the concerned file of the sub-collector. The State Council is directed to produce the file in which the matter relating to disengagement of the petitioner was dealt with. List this matter by question for us. List this matter on 10 July. No. And you may do also one thing. There is one judgment of my judgment. Have you gone through that judgment? Maternity leave. Denial of maternity leave amounts to violation of Article 21 of the Constitution. Find out. Find out. Yes.
I don't know, 19.
My lord, in respect to item number 19, my lord, it was the last week, my lord.
The full compliance affidavit.
Yes, ma'am. With respect to payment of all the areas, my lord, that has been worked out. Only with respect to payment of the interest. The DO has made request, my lord, to the authorities to place the funds and according to issue the instruction, my lord. And that has not yet been.
It will be done. I will keep it pending.
Yes. Lordship may keep it pending.
What do you say?
In the reopening, my lord. It will be.
Another affidavit you have filed? No, you have not filed any affidavit. Achha, how?
No affidavit, man. Last time, last week.
फाइल करछन्ते हमें देइनु बोली इंटरेस्ट बाटा देइना बोली दे पहिले
Already affidavit करके दे दी. I just need some time.
When did you file that affidavit?
Hello, that is on.
No, that is earlier. That is earlier.
Yes, 20th/12/2023.
Sri S.N. Patnaik, Learned State Council, submits that the District Education Officer, Ganjam, has requested the government. Has requested the government.
Government as well as the secondary.
As the government, of course, as the government, for release of funds to pay the interest component to the petitioner. He further submits that what amount has been paid?
The
that the dues.
Order of the Honorable Court, my lord, to release the pension and other benefits, my lord. Everything has been complied.
That all other dues
Yes, ma'am.
as directed by this court have been paid.
Yes, ma'am.
We'll grant him some time. In such view of the matter, list this case July.
July. First week of July.
10 July. Full compliance affidavit will be filed in the meantime.
Yes.
Yes.
Item 20. My lord, I am the petitioner is the wife, my lord, of the opposite party. The opposite party filed a petition the under section 13(1) but divorce, my lord, with the court at London Judge Family Court Raurkela. With my lord, the petitioner seeks transfer to the court, my lord, at Parala.
Any settlement? Chance of settlement?
Chance of settlement, my lord. From
What do you say, Mr. Naik?
Direct the text.
No, if you say I can send it to the mediation center. If not, then we'll hear the application on merit. Whatever you say. In all matrimonial cases, there will be an endeavor by the court to see whether the matter is settled or not. You are staying at Raurkela?
No, both are no.
I am staying at
Both are they residing outside the present. Husband is residing in Rajasthan, Jodhpur, Melod. The wife is in Gandhinagar in Gujarat, Melod. Both are service, Melod. The wife is the.
We will call them to Cuttack,
Melod.
High Court Mediation Center. In course of hearing, it is stated at the bar that there is a possibility of the dispute between the parties being settled amicably through the process of mediation. In such view of the matter, place the record before the coordinator Odisha High Court Mediation Center, so and so, so and so. List this matter on 17 July.
Fine.
All right.
So mediation will fix the date for it.
17 July. Mediation is seminar. That order which normally I pass. That parties are directed to.
Mediator will give the date.
He will issue notice. That order will be there. Don't worry.
Item 21.
Item 21. Notification the order. The order correct. The order will be corrected accordingly. Yes. Yes, Mr. Mahapatra. 2023 matter for final disposal.
No, sir. I am submitting the counter affidavit.
You are filing?
Party number 5.
Who are you?
Opposite party number 5.
Who is opposite party number 5?
Contesting opposite. Sir, contesting.
Contesting means ki hai?
Rasmita Sahu.
The selected candidate.
Selected candidate.
I am telling you her selection.
See, bully, pachale apna koi bhi unse. Good. File the counter. Counter affidavit is filed in the court by our counter affidavit of opposite party number 5. 5 is filed in the court after serving copy on the other side. List this matter.
Vacation.
After vacation, obviously. 17 July. 2023 matter, Mr. Mahapatra, why are you looking so worried? 2016 matters are there?
All are interested in their own case.
Item
22.
22.
The Lordship, I will see the order at 10/4/2022.
Draft counter is ready. I will file the final by next week.
10/4/2022.
Sri Ardas Learned State Council submits that the draft counter affidavit is ready and that the same would be finalized and filed by next week. List this matter after vacation. Date karo. 17 July. Counter affidavit will be filed by next week, positively. Yes.
Entry order.
After serving copy on the other side, interim order to continue.
Item 23.
What is this letter received from Apex Court?
Yes, my lord, I
What is the order?
order, my lord, try Hon'Ble by as per the terms and
Granted by the High Court shall be extended. Gala. Tapre?
final order has been passed. Uploaded company I have collected.
Final.
He has surrendered and released on date.
This time is granted to learn counsel responsible file. Symbol granted is to continue. Tapre kon?
Final order. Yesterday he has also surrendered.
Is granted bail subject to conditions as may be imposed.
Yes.
Huh. So?
Yes, surrendered and released on bail.
Why surrender? Allow hela bail allow hela pura.
Yes, my lord.
Surrender kon kari.
ସେ ସରେଣ୍ଡର କରି ବେଲ୍ ହେଲା।
ମାନେ bail ରେ ଗଲେ ତ?
Yes, my lord.
ବର୍ତ୍ତମାନ କଣ କରିବାର ଅଛି?
କିଛି ନାହିଁ dispose of lordship.
କଣ ଖାଲି this is a dispose of case.
Yes, dispose of case ଟା ପଳେଇ ଆସିଥିଲା।
କାହିଁକି ଆସିଛି? ଏଇଟା ଆସିଛି ବୋଲି ଖାଲି ଆସିଛି। କିଛି କରିବା ନାହିଁ।
କିଛି ନାହିଁ lordship close।
In view of the order passed by the apex court, by the Supreme Court, no further order needs to be passed in this case. Yes. Item 24.
Item 24.
May I please proceed?
Called extension of time.
My prayer in this time, my lord, extension type and your lordship's order kindly see para 10 I my lord.
Para 10.
My lord.
Yes.
Each every Sunday, my lord. That 2 weeks appear କରିବାକୁ I pray, my lord.
When every Sunday to issue kon asudha hoyi.
My lord, she is working, my lord, in a company, my lord.
No, this is that Jagan murder case.
A mobile dude ports, my lord. Say this saptara.
That murder case, that auto rickshaw. हाँ, oh, नहीं बाप रे, कहीं मु कहीं करची ये बेटा कहीं करची मु जानने क्या? Why did I? No, hardened criminal. So that is why I've said that he will appear before the IAC of Rama Police Station on every Sunday at 10 AM for a period of 6 months.
Extended time, my lord.
Time will be extended. What time?
Surrender matter.
Okay, okay. Prayer for modification is rejected. Prayer for extension of time is allowed. 2 weeks further time is granted. Yes. Sala. Gote pass over. Kuda. So, Dr. Lenka. Year पर करिए very urgent. कितने item कितने?
The vacancy is there.
Item कितने? Item 4. It was heard. It was parted.
Parted. So lordship last occasion directed to
to submit that original like oh that matter. Yes, yes. काहे कि तांको आपण ignore करी कि
post staff strength टा कोण ଆଉ ଏଟା ମତେ ପଚରା ହେଇଥିଲା
the State Council is requested to ascertain the admissible staff strength of the institution if necessary for producing the relevant order. Yes. You have to give a copy to Dr. Lenka.
I have already. Staff already post is there. Another
ଏଥର ଆମେ prompt ହେଇଯାଇଛୁ ଆଗ ତାଙ୍କୁ ଦେଇଛୁ
so ଏଇରେ ইয়াର ନିର୍ଯାସ କଣ
ସେ ଏଥିରେ ଆମେ staff strength ଟାକୁ ଆମେ ଦେଖେଇଥିଲୁ ଯେ head clerk ରେ ଗୋଟେ senior clerk ରେ ଗୋଟେ accountant ରେ ଗୋଟେ junior clerk ଦିଟା so
third post जे अछि से जो accountant पाइ देन UD clerk टा vacant अछि
senior clerk is vacant दे देबो आपको next week रे पास करे order टा
this may be taken into
or will काली कौन मैटर अछि काली order टा पास करते okay he is not allowing so I will not no he handles the very difficult job for him. Had it been one assignment, it would not have been so difficult. But because of the multiplicity, so I directed Sri Patnaik Learned State Council files written instructions
indicating
the admissible staff strength of the institution, along with the relevant orders.
Yes.
Same be kept on record. A copy of the said instruction has already been served upon Dr. Lenka, Learned Counsel for the petitioner. List this matter on 13th May. And Somar then. On that day, if necessary, we will complete it. All. List is over? Good.
On 8/2023, the FIR my lord 7 to 8 line after my lord.
Yes.
On suspicion, while we halted our patrolling vehicle near the spot, those 2 persons sitting on the jury back tried to escape from the spot. On chasing them, I could clearly observe that one of the escaping person was Dipti Lima, Swanso, village Swanso. I called him in the name, but escape. My lord, the present petitioner is Dipti Lima, my lord. Nothing recovered, my lord, from his possession, but the police, my lord, on suspect found that the said person is Dipti Lima, while my lord, he escaped from this spot. This is only the allegation, and the petitioner, my lord, custody since 31/8.
Any antecedents?
My lord, there is two
He
antecedents, my
was
lord.
remanded in this case.
There is two
The similar offences, he was in the custody.
Not similar, my lord. That is 20A, my lord, in
No, no,
cultivating, my lord.
no, I will not grant it.
My lord, kindly see rejection order.
No, no, I will not grant it. The petitioner is in custody.
You'll also kindly see the rejection order. It is, my
I
lord,
will not grant bail, sir. The petitioner is in custody.
21A, my lord. That
Who came to end the petitioner is in custody in connection with such and such case.
20A, I.
It is alleged that the petitioner was in possession of petitioner and another person was were in possession of contraband ganja weighing more than 100 kgs when they were detected by the police officials. So it is stated that when seeing the police, the petitioner ran away and escaped. But he being a noted drug peddler of the area, police could identify him. Stop. Then State Council commits that the petitioner has similar antecedents. Taking into consideration the above fact, as also the fact that the contraband involved is more than commercial quantity, I am not inclined to allow the prayer for bail, which is therefore rejected. Yes.
Then I pray, my lord, for early.
Yeah, it is. He the reject
Charge frame already here. What a witness be here. Lots of early.
What early?
Early display.
No, no, no. You are making this prayer, Mr. Das, without realizing the consequences it will have on the officer. Because immediately when the High Court passes this order, a red flag will be attached to the file. And he has to submit explanation. Wait, he has to submit explanation to the High Court every month.
My prayer, after that, my lord,
very difficult.
Can renew his prayer, my lord. That's why
it shall be open to the petitioner to renew his prayer later. I have left it open so that you can.
Item 52.
And moreover 1 year, hey, otherwise I would have, yes, pass over.
Item number 53.
May I please also that petitioner is in custody in connection with case of offence under section 20A and 27 one of the.
Have you filed any affidavit as directed about your antecedents?
Antecedent gote achi rejection copy lekha ichi antecedent.
But there was an order passed by Justice Satpathy S.K. Sahu. Let the 11th Council of the petitioner obtain instruction about the status of such case and file a comprehensive affidavit to that effect. You directed.
Already say mention achi status ta achi he has granted.
So this order, how can I ignore this order? This is a judicial order passed by a coordinate bench. How can I ignore it? Had it been my order, I would have recorded.
That is taken.
I would have recorded. But this is an order passed by a coordinate bench. So you file a comprehensive affidavit for whatever. Kete kg? Kete kg?
Kg no 400. ଗଛ ଲଗଉଥିଲେ ପଳେଇଲା ଦୌଡ଼ିକି he was identified by the ଗ୍ରାମରକ୍ଷୀ.
By the grammar he was identified.
The petitioner is in custody since?
He was arrested and remanded 23/8. 23/8/2023.
Sri Zafarullah, 11th Council appearing for the petitioner submits that the details of the previous case registered against the petitioner have been mentioned in the order of rejection passed by the court below. And therefore, he may be exempted from filing the comprehensive affidavit as directed by this court. So, after perusing the order of rejection,
page 14, madam.
This court finds that
involving the same similar offense, NDPs.
That the details of the previous case have in fact been mentioned therein. In such view of the matter, the filing of comprehensive affidavit is dispensed with. The bail application is taken up for hearing. Stop. The petitioner is in custody since
23/8/2023.
23/8/2023 in connection with such case. It is alleged that the petitioner had planted.
Petitioner and others thile.
The petitioner had planted cannabis plants over government land, and at the relevant time, 3 persons were found clearing grass from such field. Stop. And the petitioner was identified by the local grammar Rakhi. Considering the nature of accusations, the materials on record, and the period of detention in custody, I am inclined to allow the preferable. Let the petition be released.
Custodian 23/8/23.
23,
23/8/23.
Serious condition है तो
23/2023.
Yes.
Item 54. Item 54, my lord, in this case, other co-accused disposal, my lord, justice is आपके पक्ष में.
This must have come. So it is submitted by learned counsel to the petitioner that the earlier bail applications of co-accused persons have been disposed of by Honorable Sri Justice R.K. Patnaik. Registry to do the needful after obtaining necessary order from the Honorable the Chief Justice. Yes.
Item 55.
Item 55, yes. Yes, item 55. Pass over.
Item 56.
My lord, under section 20B 2IC of NDPS Act, my lord, are the preservation in custody, my lord, 5th of March 2023, my lord. And ganja was seized, my lord, from this conscious possession, my lord, 50 kg, 870 grams, my lord. And last time, my lord, I have mentioned that the present person has residing in Jharsuguda, at Jharsuguda, last 15 years, lordship. Therefore, lordship, to take instruction.
For 15 years.
Yes, my lord.
In order dated 18/4/2024, the word days occurring in paragraph 2 be corrected as years. Then State Council has produced written instructions of the IIC that to the effect that the petitioner has been residing with his family members in a rented house at Purna Basti, Jharsuguda. But none of the witnesses stated that he was staying at Jharsuguda since the last 15 years. Stop. In view of the
Custody, my lord, more than 1 year, my lord.
in view of such wrong submission made before this court is not inclined to entertain the bail
Present
application,
person has two sons.
which is therefore rejected. Yes.
Item 57.
How was it? Learn how to lose cases. Learn how to lose cases, then you will start winning cases. Ask Mr. Patel. He will tell you.
Renew prayer after examination.
It shall be open to the petitioner to renew his prayer after examination of later will get it. Yes.
Item 57.
Item 57, yes.
Your lordship. These two petitioners are accused of offense under section 20B2C. The quantity of ganja involved in this case here is 40 kgs, and there are two persons. They are in custody since 4/3. They are in custody. 3/9/2023.
3/9/2023.
My lord. But I submit before my lord the prosecution case here now that the informant detected the ganja near Kumuliput, which is towards north of from Jaipur, Jaipur police station here. But the witness belonged to Pampuni, that is 12 kilometers.
No.
40 kg ganja was seized from his consciousness.
No. The petitioner is in custody in connection with such and such case. It is alleged that the petitioner was in conscious possession of 40 kgs of contraband ganja when he was apprehended by police. It is alleged that two persons were carrying a jerry bag in a scooty. And on suspicion, the police party detained them. On search, it was found that the bags contained 10 packets containing ganja, the total weight of which was 40 kgs. ବର୍ଷେ ହେଇଥାନ୍ତା ଅଲଗା କଥା, ବର୍ଷେ ହେଇନି ହବନି। Having regard to
My lord, I am permitted to withdraw the petition with the liberty to file afresh.
all right, permitted to withdraw with liberty to file, liberty to renew his prayer later. Yes.
Item 59.
May I please? Lord, in this case, the offense is under section 376.
Notice has been issued.
No, no, your lord.
The notice is you. Let an extra copy of the bail application be served upon Land State Council, who shall ensure notice to be served upon the informant / victim, indicating that the matter shall be taken up for hearing on
The week commencing 24th.
in the week commencing 24th June. Reopening.
Before vacation, if possible.
Before vacation, notice will not be served, and we cannot take up this matter.
Custody, my lord, near about 1 year.
So one more month, what is there? Yes.
Item 60.
The last occasion, my lord, has called for the victim statement.
He's seen that 4 witnesses include the victim. He would like to produce the reposition. The court will is directed to transmit copies of the victim. Victim was examined as. Oh my God, Muhammad. ସବୁ କଥା କହିଛି ଆଉ କଣ? He stated everything. The petitioner is in custody since
29/6/2020.
29/6/2020 in connection with such and such case. It is alleged that the petitioner forcibly committed rape on the.
In fact, very poor lady. ତା ପିଲା ବର୍ତ୍ତମାନ ସ୍କୁଲ ଯାଇପାରୁନି, ମାନେ ଏମିତି ଅବସ୍ଥା।
ପ୍ରାଇଭେଟ ଫାଇନାନ୍ସ କମ୍ପାନୀରୁ ଲୋନ କରିଦେବେ ବୋଲିକି 11,35,000 ଟଙ୍କା। And she has also made an agreement କି ଫେରେଇବେ ବୋଲି. That is reflected in the charge sheet, but not.
The petitioner is in custody since
17/10/2023.
17/10/2023 in connection with such and such case. It is alleged that the petitioner collected huge amount from the informant and other villagers with promise to refund the same within 6 months. However, she did not return the said amount. Moreover, taking advantage of the ignorance of the informant and the other ladies, she induced them to avail individual loans from non-banking financial companies, which they availed, but the petitioner is alleged to have taken the same away. It is submitted that the allegations are false and baseless and have arisen because of dispute among the members of the group. In any case, charge sheet has already been submitted.
Yes, ma'am. Charge sheet submitted.
Considering the submissions as above, the fact that charge sheet has already been submitted, as also the fact that the petitioner, being a lady, has already been in custody. 10 ମାସ ରହିଲେଣି ପରା
17/10/2023
10 ହେଲେ କେତେ ହେଲା 2 ହେଲା 5 7 for nearly for more than 6 months. I'm inclined to allow the prayer for bail. Let the petitioner be released.
Item 62.
May I plead the lordship. My lord, offense under section 21C, 29 of NDPS Act.
Yes.
The alleged occurrence took place on 7/9/2022. the present petitioner was arrested on 17/2022 while he released on bail in connection with the Sadakhunda PS case number 352 dated 27/22. While he was just come out from the jail, he was apprehended outside the jail. But the forwarding report dated the Annexer 6, running page number 62, it clearly reveals that he was apprehended at Baleswar bus stand. My lord, have a glance to the Annexer 1, that is the running page number 6 to 15. In page number 9, my lord, affair, in the formal affair, the name of the present petitioner does not find place. Even in the written affair, the name of the present petitioner does not find place. The preliminary CS was submitted on 4/3/2023. The name of the present petitioner does not find place. Basing on the affair as well, though preliminary CS was submitted on 4/3/2023 and prosecution cited 16 witnesses, none of the witnesses whispered a single word the name of the present petitioners. On the other hand, the person who apprehended at the spot, namely Ruga alias Rafiq, he clearly stated that he procured the brown sugar from Sheikh Raja of Order Bazaar. And basing on that, my lord, the formal affair was drawn. So I just permitted to Your Honor to read the formal affair. The allegation in the affair, subject report against Sheikh Rafiq alias Ruga, address such and such, formal address such and such, Sheikh Raja, son of late Sheikh Khurshid of Golapur Order Bazaar, such and such. The name of the present petitioner does not find place. Subsequently, my lord, when the present petitioner was implicated in the Sadakhunda PS case number 352, dated 27/2022, and he released on bail on 17/6/2023, he was apprehended on the same day at 3:30 p.m. That is the forwarding report Annexer 6, my lord, running page number 62 to 64.
Yes.
And the present petitioner, though charge sheet was submitted on preliminary charge sheet was submitted on 4/3/2023, the present petitioner are implicated basing on the statement which was recorded on 5/4/2023.
There is there, my lord. He was one Chandan Das and Chitranjan Panda.
They have dealt with a similar matter. They have dealt with a similar matter where there was, it is claimed that they were arrested outside the jail gates.
Yes, madam.
After being released in
It
another.
has been seized from one Sheikh Rafiq.
All right.
But he has one criminal incident of similar nature.
No, I'm not going to grant bail. I'm not going to grant bail. I will ask you to just find out about this. If he has, if he has not been named in the affair and not in the preliminary charge sheet, on what basis has he been implicated? Let us see the forwarding report.
My lord.
Place the forwarding report from second paragraph.
My lord, forwarding report.
Second paragraph.
Second paragraph.
Yes.
My lord, in the forwarding report in the second paragraph 62. During the course of the investigation, it transferred them 7/9/2022 at 4:30 AM. The Inspector Diptiranjan Pradhan received credible information from source to the effect of one person, namely Sheikh Rafiq Ruga, Order Bazaar, Baleswar town, who is a habitual dog trader dealing with brown sugar in mobile manner in Order Bazaar locality. He further intimated then on 7/9 in between 11 to 12 noon that said Rafiq was planning to deliver the bulk quantity of material brown sugar to the customer Masjid Gali near Order Bazaar railway level crossing, Baleswar. Basing on the information, Inspector Diptiranjan Pradhan with the other staffs, official witnesses conducted raid at the above noted place following due procedure law, procuring two official witnesses, namely Mananjan Naik, such and such address, and the present working as junior revenue assistant, and another Sri Harimohan Singh, address my lord such and such, senior revenue assistant, sub collector Baleswar. Inspector Diptiranjan Pradhan detected illegally possessed 1 kg 380 gram quantum brown sugar and the other incriminating articles by accused person Sheikh Rafiq alias Ruga, address such and such, Your Honor, and seized the sealed envelope packet containing bulk brown sugar marked as UDA, along with the airbag, 2 numbers of mobile phone, and 1 black color money purse containing cash of rupees 2,930 of different denomination in the presence of witnesses exhumed on 7/9 at 3 p.m. from the exclusion conscious possession of Sheikh Rafiq after following the procedure of NDPS, as he could not furnish any document authority support of the such possession of brown sugar with him. During the interrogation, accused persons confessed that he used to carry brown sugar business in the locality after procuring the same from one Sheikh Raja, son of late Sheikh Khurshid of Golapul Autobazar, PS Sadakhunda district Baleshwar on 7/9/2022. As per the direction of Sheikh Raja, he has come to the Autobazar level crossing to deliver the brown sugar to a person where he was caught red-handed by the police. He further added that the seized brown sugar had given to him by Sheikh Raja as a noted drug peddler against whom the number of cases pending. My lord, the present petition was implicated basing on the statement of the two witnesses, namely Chittaranjan Ponda and
What is your name? Your name is Rafiq or Ayub?
Sheikh Ayub.
Ayub. But there's no mention of Sheikh Ayub here in this forwarding report.
Last but one paragraph, that
Yes.
forwarding report.
Yes.
During course of further investigation, examined local independent witness, namely Sri Chandan Das, age such and such, and Chittaranjan Panda, such and such. During examination, the witness Chandan Das and Chittaranjan Panda stated to have seen the accused person, namely Sheikh Raja and Ayub, at relevant point of time near Balesar railway station. They have further stated that they have seen Ayub handing over one black and maroon color airbag to Sheikh Rafiq, who after receiving the said airbag proceeded towards railway station. Their statement further reveals that thereafter they have seen some people in plain clothes identifying themselves as police personnel caught hold of Sheikh Rafiq, whereafter they left the place. Subsequently, the above witnesses came to know that Sheikh Rafiq had carrying the brown sugar in the said black and maroon color airbag. The witnesses claim to identify Sheikh Rafiq Ayub if shown to them.
My lord,
This Ayub is from Madhya Pradesh.
my lord, I have been permitted the Chittaranjan Ponda and Chandan Das, both are the stock witnesses. My lord,
Yes.
my lord, have a glance to the
All witnesses are stock witnesses.
my lord, I just attention of your honor, my lord, my lordship, my lord, have a glance to the page number, running page number 92 and 93 for 92 running page 92, my lord. I have the document, subsequent document was filed on 3rd April 2024 and copy was served to the on London AG on such as 2004. In both the witnesses, they have examined in connection with the Sadakhunda PSK number 366. Somebody bullying the my lord have permitted to read the witness statement of Chittaranjan Ponda, which was recorded in connection with Sadakhunda PSK number 366, dated 12/11/22. मोर नाम चित्तरंजन पंडा आज आपण निकट बयान देउछि कि जे एई आज
Charan.
basing on these two statements present petition has been implicated.
No. He is an outsider.
Yes, ma'am.
Any stringent condition?
No condition can be stringent enough to bind an outsider.
And another similar nature that 10 kg 518 grams.
Neither the statement of the co-accused nor the statement.
No, Mr. Bera. No.
Lordship accused has not whispered a single word that he procured the brown sugar from Ayub.
That is a matter for trial.
Lordship, during the submission of the preliminary charge sheet, even if name of the present petitioner does not find place, subsequently the statement of other two witnesses, that is the stock witnesses alleged that they have earlier occasion that these two witnesses examined in connection with Sadakhunda PS case number 366. These two witnesses only see that the name told the name of the present petitioner. Apart from that,
he also has criminal antecedents.
Yes, my lord.
only one antecedent.
10 kg.
Released on bail.
No. Enough.
My lord, why was released on bail? I have apprehended from in front of the jail gate. That is important arrest memo shows that he was apprehended at Boston on the same day, my lord.
In same PS, Sadakhunda PS case number 5222.
And he is languishing jail custody in this in connection with this case. 18, my lord, he arrested on 17, forwarded remanded forwarded on 18.
On 17/6/2023 case in connection with such and such case. It is alleged that the petitioner was involved in illegal dealing with illegal dealing of contraband brown sugar weighing more than 1 kg. Stop. It is submitted by Sri Behra, learned counsel for the petitioner, that the case has been fostered falsely against the petitioner only to detain him in custody after he was released on bail in connection with the previous case. Stop. He further submits that the petitioner is not named in the FIR or in the preliminary charge sheet, but basing on the statement of 2 persons, who are stock witnesses of the prosecution, the petitioner was arrested. Even otherwise, the statement of the witnesses do not implicate the petitioner in the alleged occurrence in any manner. Learned State Counsel opposes the prayer for bail by submitting that there is no reason to treat the witnesses as stock witnesses. Furthermore, the petitioner is a habitual offender, being involved in a similar case involving more than 10 kgs of brown sugar.
Yes.
The grounds raised by the petitioner can be considered during trial. Having heard learned counsel for the petitioner and the State Counsel, and upon going through the materials on record, including the statements of 2 witnesses examined by the IO, namely Chittaranjan Panda and Chandan Das, this court finds a prima facie case against the petitioner in as much as he is said to have handed over the bag containing brown sugar to the co-accused Sheikh Rafiq. Stop. As regards the reliability of the witnesses, same is a matter to be raised during trial, but not at this stage. Taking note of all the above facts, the quantity of contraband involved, as also the criminal antecedent of the petitioner in similar offense, I am not inclined to allow the prayer for bail, which is therefore rejected. Yes.
Item 63.
My lord, 376(2) and 6 of POCSO. Notice or issue.
Notice ଯିବ କାଇଁ
Information.
notice ତ ଦରକାର
PSST Act.
Already sir.
PSST Act ରେ ପୋକ୍ସୋ ଅଛି ନା
POCSO ଅଛି ଯାଇଥିଲା notice.
ପୋକ୍ସୋ ଥିଲା ଆଉ ଯିବା ଦରକାର ନାହିଁ ତ anyway Learned State Counsel informs that notice on the victim/informant has been served on
9/4/24.
9/4/2024. There is no appearance for which the bail application is taken up for hearing. You have the statement?
Yes, ma'am.
Yes.
My lord, 164. Last person.
But subsequently petition was forwarded under section 498-306 IPC at page 12, annexure to lordship, second paragraph. Kindly have a glance. The marriage took place. I am the husband. 2 years back, the marriage took place. Subsequently, happy conjugal life for about 2 years on the day of alleged that due to some the petitioner suspecting the character of his wife, a quarrel took place regularly. On the day of occurrence, there is a quarrel between the petitioner and deceased. Thereafter, Manopangi was speaking of quarrel with the wife Padmapangi in silly matter and assaulting or suspecting her character. And at about 8 p.m., Manopangi again picked up quarrel with his wife, for which the Padmapangi, without any reason, consumed insecticides which was used in cabbage cultivation and throw the bottle on him. This is the allegations.
No. Directly, sort of directly, hello.
Here you,
There's a series of misconduct in the sense that he came home drinking and he suspected the fidelity of his wife and made many verbal abuses. And on just before the occurrence, he was drunk.
This is this.
Insecticide pila, 306 kuda 306.
But the lordship inside the custody for about 9 months. A small baby.
Matro 9 months.
Small baby.
Mr. Bhupta, you are a seasoned man, but 9 months.
Small baby. Nobody is there to look after.
The petitioner is in custody.
May I permitted to withdraw with liberty to move after some time also?
Yes. Permitted to withdraw with liberty to renew his prayer later.
Item 65. May I please, lords. The petitioner custody since 24/23. Alleged evidence 20B 125 kg of ganja. My lord, out of 10 charge sheeted witness, till yet no witness are examined. 21/4/2023.
ବର୍ଷେ 125 kg melon and
this is not after vacation. Pura vacation per good date for
8 July.
8 July. We commencing 8 July.
Item number 66.
66, my lord, on behalf of Mr. Ponta, may be permitted to play in the case of 302 and 307, my lord, and the dispute for digging a well, my lord. So for the allegation of assault, one person has been killed, my lord, by virtue of that incident, namely Karthik, my lord. So far the assault part is concerned to the deceased is concerned, my lord. One. Dolia Devuri assaulted to the deceased Karthik by means of, my lord's, stone, my lord. And so far the role of the present petitioners are concerned, my lords, because, my lords, it is a case of sudden provocation. Means, my lord, that incident was taking place earlier at in the morning, my lord. Subsequently, the informant and their family member went and asked them why they restrained to dig the well, my lord. That is the fact, my lord. And at that moment, my lord, the incident taking place, my lord. And so far the allegation of assault is concerned. One, my lord, the witness, my lord, the complainant, one Ganeshwar Barik, who has stated that, my lord, that Dolia Devuri Dhorithira Eko Pothara mo bhai Karthik Barik upare phapade debaru tanka mundo patigala te tole padiga. And so far the assault to the other injured person is concerned, there is a common omnibus allegation that all the accused person, my lord, assaulted by means of tanga, pathara, fish plus, so and so. So it is all the, my lord, omnibus in nature, my lord. And so far the assault to the deceased is concerned, that is specifically Dolia Devuri. And Dolia Devuri is not the petitioner, my lordship. That apart, my lords, the petitioners are, my lords, young boy, petitioner one, my lord, the young boy of 22 years, and 2 is 60 years, and 3 is 30 years, my lords. Custody, my lord, since 6/4/2023. And charge sheet had already been submitted on 31/7/2023, my lord.
Yes. Last occasion, your lordship heard. Not inclined, your lordship said put up one move. All have assaulted, my lord. He is saying that Dolia Devuri hatare eko sakta pathar dhari mo badappa.
Dolia Devuri is not petitioner.
Here is not petitioner, but all are there. They have assaulted in. Tapare your lordship. Kalia Devuri.
Kalia Devuri is also not petitioner. Babuli, Kanduri, and Ananta.
And Kulamani.
ନା ନା ଏତେ 3 ଜଣ
ନାଇଁ କୋଡିଏ
ତା ପରଟାରେ CD is there in that.
ନାଇଁ ଆମେ ଏଇଟା କୁହନ୍ତୁ ଆରଟା ଦେଖିବା
Yes, ma'am.
ଏଇ 3 ଜଣଙ୍କ ନାଁରେ କଣ ଅଛି?
କାଳିଆ ଦେଉରୀ, ପିଣ୍ଟୁଆ ଦେଉରୀ, ଅଭି ଦେଉରୀ, ବିଷ୍ଣୁ ଦେଉରୀ, ମାନେ ସେ ପଡିଗଲା ପରେ ହାତରେ ଧରିଥିବା ବାଉଁଶ ଠେଙ୍ଗାରେ ତାଙ୍କ ମୁଣ୍ଡ, ଛାତି ଓ ଦେହ ହାତକୁ ବାଡେଇ ପକେଇଲେ। ଅମିନ ଦେଉରୀ, ଅଭି ଦେଉରୀ, ଭଗିନ ଦେଉରୀ, ଦୋଳିଆ ଦେଉରୀ, ସନିଆ ଦେଉରୀ ମାନେ ମୋ ବଡ ବାପା କାର୍ତ୍ତିକ ଦେଉରୀ ସହ ମୋ ବାପା ଗଣେଶ ଦେଉରୀଙ୍କୁ ଧରିଥିବା ବାଉଁଶ ଠେଙ୍ଗାରେ ବାଡେଇ ରକ୍ତାକ୍ତ କରିଦେଲେ। ଏହି ସମୟରେ ମୋ ବଡ ମା ମଞ୍ଜୁଲତା ବାରିକ ଛଡେଇବାରୁ ସେମାନେ କାଳିଆ, ଦୋଳିଆ, ଦ୍ରୋଣ, ପିଣ୍ଟୁ ମାନେ ତାକୁ ପଥର ମାରି ଖଣ୍ଡିଆ ଖାବରା କରିଦେଲେ। ସେଠାରେ ଥିବା ମୋ ଭାଇ ଭଗିନୀ ବାରିକ ବାରଣ କରିବା ସମୟରେ ତାକୁ ପିଣ୍ଟୁ ଦେଉରୀ, ଦୀପୁ ଦେଉରୀ, ଦୋଳିଆ ଦେଉରୀ, କୁଳିଆ ଦେଉରୀ, ବାବୁଲି ଦେଉରୀ ମାନେ ତାକୁ ଶଳା ସ୍ଲାଙ୍ଗ ପଥର ମାରିଥିଲେ। ଦୋଳିଆ ଦେଉରୀ, ବାବୁଲି ଦେଉରୀ, କାଳିଆ ଦେଉରୀ, କୈଳାସ ଦେଉରୀ, କଣ୍ଡୁରୀ ଦେଉରୀ, କୁଳିଆ ଦେଉରୀ, ପାଣ୍ଡୁଆ ଦେଉରୀ, ସାନୁଆ ଦେଉରୀ, ଦ୍ରୋଣ ଦେଉରୀ ଓ ବିଷ୍ଣୁ ଦେଉରୀ ଓ ତା ଭାଇ ବାବୁଲି ବେହେରା ଓରଫ ଦେଉରୀ ମାନେ ହାତରେ ଠେଙ୍ଗା, ବାଡି, ପଥର ଧରି ଆମମାନଙ୍କୁ ସଂଘବଦ୍ଧ ଭାବେ ମାରଣାତ୍ମକ ଆକ୍ରମଣ କଲେ। ଫଳରେ ମୋ ବଡ ବାପା କାର୍ତ୍ତିକ ବାରିକଙ୍କ ମୁଣ୍ଡ ଏବଂ ଦେହ ହାତରେ ଗଭୀର ଆଘାତ ଲାଗିଥିବା ଏବଂ ସାଙ୍ଗେ ସାଙ୍ଗେ ଡାକ୍ତରଖାନାରେ ଚିକିତ୍ସା ପାଇଁ ଭର୍ତ୍ତି କରିଥିଲେ। There, my lord. Babuli Deuri is there, and Konduri Deuri is also there. All have assaulted, my lord. The three injured eyewitness, the same statement, my lord. One Pratap Barik and one Govinda Barik.
What about Ananta Deuri or that Konduri Tawala? What about Ananta Deuri?
Yes, my lord, he is there.
So far that allegation is concerned, that is, my lord, assault to the, my lord, the mother of the informant. What my lord friend is stating. I humble some.
Ananta Deuri is there.
Who is the deceased?
This is Karthik, my lord. Karthik Barik.
Karthik Barik.
Dele, yera dele, 161.
And the allegation of assault and corresponding injuries are different. And in fact, my lord,
one of the injured
out of my lord, so that
this Pratap Barik is injured.
Yes, my lord. 3 injured eyewitnesses are there.
What about that? The deceased? Karthik.
Karthik.
But those who have assaulted the deceased, that will be difficult. Deceased को किए कले समस्त तो करछन हठात दलिया दौरी हाथ रे एक शक्त पथ दलिया इज नॉट बिफोर अस
No.
मो बड़ा बापा कार्तिक बारिक मुंड को लक्ष्य कर छेची देले से तळे पड़ी गला सो दलिया दौरी गॉन देन कालिया दौरी कालिया इज नॉट अ पिटिशनर पिंटुआ दौरी नॉट अ पिटिशनर अभी दौरी इज अ पिटिशनर भीष्म देहुरी माने से पड़ीगला पर हाथ में धरती बाउंश टेंगा ता मुंड छाती देह को बाड़ी पकेले अमीन देहुरी अभि देहुरी भगिन देहुरी दलिया देहुरी सनिया देहुरी माने मो बड़ापा कार्तिक सब मो बापा गणेश बारिक को धरते एठी ये जो बाबुली देहुरी और कंडूरी देहुरी ए मानकर नाही assault on the deceased assault on the deceased is specifically named ये दलिया देहुरी हाथ में एक शक्त पत्थर धरी मो बड़ापा कार्तिक बारिक इज द डिसीज तो कार्तिक बारिक मुंड को रक्षा करी से तଳେ पड़ीगला कालिया देहुरी पिंटुआ देहुरी अभि देहुरी इज पिटिशन नंबर 3 भीष्म देहुरी माने से पड़ीगला पर हाथ में धरथिया बाउंश टेंगर ता मुंड छाती और देह को हाथ में बाड़ी पके नेक्स्ट पेज
अन्य माने बाड़ी 3 persons are there.
अनुमान को बाड़ी
हाँ 3 injured persons are there. That is admitted fact manner. That is also the prosecution case and the witness concern manner, eyewitness concern. They have repeatedly stated the same thing, my lord.
I can consider बाबुली देहुरी and कंडूरी देहुरी अनंत देहुरी that अभि हबनी सेटा हबनी आ आर लोकटा कोन कुळमणी नारे कोन देखिए कुळमणी ना तो नहीं
My lord, Kulamuni is concerned. Kulia, my lord.
कुलिया देखिए ना कालिया देहुरी
No, Kulia. Kulia, my lord. Kulamuni Dehuri alias Kulia, my lord.
अभि अमीन अभि भकिन दलिया सनिया एथरे भी ता ना नहीं कालिया दलिया द्रोण पिंटू मान तो सेरा तो
Wrong question number 3, your lordship. In 1137.
कुलिया देहुरी is that injured you injuring was बाबुली देहुरी in that case how many petitioners are there
My lord, 3 petitioner in BLAPL number, my lord.
कुळमणी कैलास and द्रोण
Kulamuni Kailas Drona is concerned, that is BLAPL number 11373, my lord. And so far the BLAPL number 1304423 is concerned.
Babuli,
Konduri, and Ananta.
So what transpires is in the second case, Kulamani Dehury, Kailas Dehury and Drona Dehury, they have assaulted the injured persons. And so far as the other case is concerned, there Babuli and Konduri have also assaulted the injured persons. Abhi has assaulted the deceased. So the Abhi I will reject, I will not grant. Others have the injuries, injury con grievous.
Yes, my lord.
Ketin royalty?
Custody, my lord, I am custody since 31/7/2023.
The bail application both these bail applications having arisen out of the same occurrence are taken up for hearing and are being disposed of by this common order. The petitioners are in custody since
my lord 31/7/2023. 31/7/2023. Sorry, my lord. Sorry, my lord. 6/4/2023.
6/4/2023 in connection with such and such. The prosecution case is that when the son of the informant,
one informant,
when one Noron Barik was digging a bore well using boring machine. Using machine at that time, one Kaliya Devuri and Pintua Devuri stopped him from doing so. When Noron refused, they abused him in obscene language and also assaulted him. On the same day, at about 7 p.m., when the family members of the informant asked the villagers as to why they tried to stop the digging of the borewell and also assaulted their son, the accused persons, the accused persons and several others being armed with weapons like lathi and axe assaulted the informant's husband and brother-in-law. As a result of which, the किए मरिगला
कार्तिक मेल
से किए
कार्तिक बारी
कार्तिक कहाँ रहो कार्तिक गला कौन हुआ करो
कार्तिक इज माय लॉर्ड
बड़ा
बड़ा बाप दी
नहीं as a result one Kartik Barik expired died while others sustained injuries. It is submitted that the occurrence took place without any premeditation and on the spur of the moment. There was a sudden quarrel in course of which the petitioners assaulted the other party. Land State Council submits that there is prima facie evidence to show that because of the assault by Kaliya Devuri, Pintua Devuri, Abhi Devuri, bracketed petitioner number 3, Bhisma Devuri, Doliya Devuri, and Doliya Devuri, the deceased Kartika sustained fatal injuries. This court has also perused the statement of the injured witnesses, namely Pratap Barik, Govinda Barik, and Manjulata Barik, available in the case diary, produced by Land State Council. It is seen that the main allegation of assault on the deceased is directed against Doliya Devuri, Kaliya Devuri, Pintu Devuri, Bhisma Devuri, and Abhi Devuri, bracketed petitioner number 3. All the witnesses have consistently stated about such assault by petitioner number 3 being associated with the other accused persons. In such view of the matter, I am not inclined to allow the prayer for bail in respect of petitioner number 3, which is therefore rejected. Petitioner number 3 से ऐसे लिखे हुए petitioner number 3 real appeal number so लिखे हुए जो bail application डाल रहा है इसी
real appeal number 130
से लिखे हुए As regards the other petitioners, it is seen that the main allegation against them is of assaulting the assaulting Kaku Kumarli, husband of the informant.
उसमें से other injury person.
Assaulting the other persons belonging to the informant's family, causing injuries on them. Stop. After going through the statements of the witnesses, This court finds force in the submission of learned counsel for the petitioner that the occurrence took place out of a sudden quarrel without any evidence of premeditation being available. Under such circumstances, it cannot be definitely said that these petitioners were actuated with the intention of killing the injured persons. That apart, they have been in custody for more than a year. Taking all the above facts into consideration, I am inclined to allow the prayer for bail in respect of petitioner number 1 and 2 in BLAPL number so and so, and in respect of all the petitioners in BLAPL number so and so. Let the petitioners be released. Yes.
Reporting for petition number 3 after examination of the witnesses, star witnesses.
It shall be open to the petitioner number 3 in BLAPL number so and so to renew his prayer after examination of material witnesses during trial.
Item 67.
Yes. Let the petitioner in custody. So he has transferred that amount to his account. That is the malad point. Malad is the informant is a senior officer in NTPC.
Where is the FIR?
Last time I have seen the.
You have given that FIR?
You know, last time I submitted that charge statement. They both played game 11. That is what when the present petitioner lose entire amount in the game 11, thereafter he has filed this FIR against him. The allegation is that my lord, impersonating himself as a girl, he has defrauded this amount.
So that no. It turned out that the girl was not a girl.
No.
On Facebook, he was posing as a girl.
Yes.
And this person was very interested to talk with that so-called girl impersonating, so-called a boy impersonating as a girl. Very good.
To help her for medical treatment.
Legal treatment and all that. 34 lakhs, 37,500 were transferred. Very good. This Facebook, right? Hey, what happened to that money? 34 lakhs.
Well, they actually the fact is that they played Dream 11. So Dream 11 it was hyphen well, the entire amount. Thereafter he has filed this FIR.
What is the meaning of that?
Dream 11 well, I have no idea, but that is a
I also have no idea.
Cricket game, my lord, where money was the perhaps all the players they put their money and played. Who will win? They will receive entire amount. That is a game, my lord. Online.
The advertisement, the investigation doesn't say so.
No, madam.
Well, this is a fact, my lord. What I have obtained instruction.
You pay some money.
My lord.
You pay some money.
Sorry.
I say pay some money. I'll grant you bail.
Okay. Yes, as my lord. Please.
That is a 34. It is 34 lakhs.
My lord, the condition of the present petitioner's family, they are very low in income. So my lord, as my lord, please.
All right, furnish property security. Property security of 50 lakhs.
Not possible. Less than of.
All right, I'll make it 35 lakhs. Covering this amount.
Around 10 lakhs, my lord, they can.
No.
They are daily labor.
It's serious fraud.
But
Yes, my lord, I can accept that part. The fact is
You
that,
are now claiming that you are very poor.
yes, it's a fact, my lord. But I'm claiming that it's fact.
You are poor, but not without brains.
There are brain, my lord, that if they played this game, perhaps.
None of the, you see, the investigation does not at all point out to whatever you are saying that they were playing, what was it, Dream 11, something like
But
that.
people might not see that investigation. They have chat several times with that girl, but this is a boy. But how that correlates, man?
Since when are you in custody?
My custody from 9th September 23, my lord.
9th September 2023. Investigation to over a
Charge sheet filed.
All right. The petitioner is in custody since 9/9/2023 in connection with such and such case. It is alleged that the petitioner, impersonating himself as a girl, created a profile in the Facebook and developed friendship with the informant. In course of such relationship, he is said to have he is said to have convinced the informant to transfer huge amount to his account on the plea of spending the same for the treatment of treatment of his father. He even sent proof of the treatment in a hospital. Under such circumstances, the informant, purely on humanitarian considerations, transferred rupees 3437,500 to the petitioner's account on different dates. Subsequently, it came to light that the petitioner had created a fake Facebook profile naming himself as Shivani Panda, and also by posting a girl's image. बड़े पहुंचे हुए आदमी है आप.
Well, if you see that has been transferred to one Sumitra Behera.
Anyway.
Yes.
Learned counsel for the petitioner submits that the case as projected by prosecution is entirely different, in as much as both the petitioner and the informant were willfully participating in the online game called Dream 11. Since the informant lost money heavily, she came up with this case against the petitioner. Learned State Counsel has opposed the prayer for bail by submitting that the investigation does not reveal any iota of truth in the contention raised by the petitioner. There is proof that money was transferred to his account and has been siphoned off to some other account in the meantime. After considering the submissions of learned counsel for the parties and on going through the materials on record, this court is of the view that charge sheet having been submitted and the petitioner having already undergone incarceration for more than for nearly 7 months, for nearly 8 months, his further detention appears to be unnecessary. Under such circumstances, I am inclined to allow the prayer for bail. Let the petitioner be released, so and so condition, including the condition that he shall furnish property surety worth rupees 20 lakhs
10 lakh.
to the satisfaction of the court below. Yes.
Great.
Each the appearance before the court.
Yes.
Item 68.
May I please? Lord, case of 302. And deceased is the wife of the petitioner, my lord. And quarrel and provocation both are there, my lord. So the medical report says that, PM report says that vital part. But bruise and abrasion is the cause of death, my lord. Here, my lord, I am pressing one statement of the.
Sir, where is the FIR, Mr. Patil?
FIR of the judge.
FIR ଦେଇଛନ୍ତି ମୁଁ ପାଉନି FIR ଟା ଦିଅନ୍ତୁ
FIR is lordship that is page 7. No. Those. Those. Child witness also there, my lord.
ମୋର ବଡ ଭଉଣୀ ଶ୍ରୀମତୀ ମୋଦି ଜଣଙ୍କୁ କାଠ ଠେଙ୍ଗା ଦ୍ୱାରା ଚାଲାଣ ମାଡ଼ ମାରିଲା ଯାହା ଫଳରେ ସୋମବାର ଦିନ 12 ଘଣ୍ଟା ବେଳେ ମୃତ୍ୟୁବରଣ କଲା। ଆଚ୍ଛା କିଏ ଦେଖିଛନ୍ତି? ଜାନି ଦେଖିଛନ୍ତି କଣ ଲେଖିଲା କି ଜାନି?
ସେ ଇଏ ଚାଇଲ୍ଡ ୱିଟନେସ୍ ନେମଲି ନିର୍ମଳା ମୁଁ ସେଟା ଫୋଲ୍ଡ କରିଦେଇଛି 8 ବର୍ଷ ତାର
ସେ କଣ ତାଙ୍କ ଛୁଆ 8 years old ମୋର ନାମ ଚିଙ୍ଗୁଡୁ ଜାନି ଏଇ ତ
ତାର ଆଗଟା
ନିର୍ମଳା ଚାଲାଣ
ଆଜ୍ଞା
ନିର୍ମଳା ଚାଲାଣ ଆପଣ ମୁଁ ଆମ ଘରର ବଡ ଝିଅ ଗତ ରବିବାର ଦିନ ମୋ ବାପା ହରିଚାଲାଣ ଆମ ଘରେ ମାଗୁଣି ଯାଇଛି ବାପାଙ୍କ ଘର ये तो very important ଜିନିଷ ମୋ ବାପା ମୋ ମାଆ କୁ ମେଡିକାଲ ନେଲା ନାହିଁ this subsequent conduct is very important
yes lord
very significant and relevant also
ଯାହା ଫଳରେ ଗତ ସୋମବାର ଦିନ
had it been just an out of on the spur of the moment ସେ ଗୋଟେ ବାଡି ଦେଲା
okay
ତାପରେ ଯଦି ବାଡି ଦେଲା he would have taken his wife to the hospital because କାନରୁ ତାର bleeding ହଉଥିଲା ତା କଲାନି ଯାହା ଫଳରେ ଆମେରିକାରେ କେତେ ଦିନ ରହିଲାଣି କଷ୍ଟରେ
13/12/2022
13/12/2022
PM report also there, Lord. 2 bruises, 1 lacerated, 1 bruise. Vital part ko
head injury leads to
yes,
procedural
yes,
over temporal area comprising vital part of the brain, hemorrhage due to rupture of anterior branch of middle meningeal artery.
Epidural hematoma over temporal area comprising vital parts of brain, hemorrhage due to rupture of anterior branch of middle meningeal artery. And tympanic membrane of left ear,
respectively causing
death.
The upper bruise and lacerated vital part assaulted to by vital part.
Okay.
Not a great force, Lord.
Yes.
This is जोर रे मारे में.
हमारे लेकिन सीधे hematoma है ना?
Lord.
It caused a hematoma.
Provocation, quarrel, both are there.
Not, it can't be said provocation. It can only be said a sudden quarrel.
Yes.
Only a sudden quarrel, whatever may have been the reason. It cannot be said a provocation. Husband and wife, there is a quarrel. So he picks up the problem is he did not take him to the
hospital.
That is the problem.
Yes, sir.
Otherwise, I would have immediately granted you bail. The problem is that he did not take him to the hospital. So his conduct becomes suspicious. It adds to the theory that he was actuated with the intention of killing him. Okay.
After vacation.
Please, this matter, list one moved.
Item 69.
Please, Lords. On behalf of Mr. M. Maji, offense under section 452, 354, 366, Indian Penal Code and 25 and 27 of the Arm Act. Subsequently, the offense is returned to 302, my lord. The petitioner is in custody on 13/10/2022, my lord. 30/10/2022 से custody ଅଛି. Trial already commenced, my lord. 22 witnesses already examined. None of the witnesses say anything against the my lord, the petitioner, my lord. No criminal antecedent, nothing, my lord. He is prosecuting in a engineering college, my lord. Or one of the co-accused, my lord, religion well.
Oh.
Only allegation, my lord, against the Yogendra and his son.
Achha.
There are several witnesses have stated directly.
No, so far the petitioner is concerned, my lord. None of the witnesses, my lord. So far the PW1 is PW1 is the informant.
Sanatan Rana.
My lord, Sanatan Rana.
Yes.
My lord. PW1 is the informant, and she is also the eyewitness to the occurrence.
Yes.
If your lordship will see her evidence only allegation against Yogendra and his son. My lord.
You are one of the accused?
Yeah.
Sanatan Rana.
Sanatan Rana.
Yes.
My lord.
So he says that I know all the accused persons of this case standing in the dock, as I have seen all of them on the day of incident. This is very important.
My lord.
Then he says the deceased is my husband. Then she says the incident took place on 16/7/2022 on a Saturday at about 1:30 p.m. At that time, all the accused persons being armed with weapons like Honda, Katti, etc. had forcefully entered into our house.
My lord.
My lord, kindly say PW3, my lord.
PW3 भी देख सकते हैं?
Page 36.
Yes, very clear.
Please stated that he is also one of the eyewitnesses.
So far, my lord, PW3 is concerned. He is the Bhauja of the informant.
And
they are interested witness, my lord. So, my lord, he is in custody since 13/10/2022. He is also a student, my lord. He is prosecuting his study in engineering.
The Mauser was seized from the present petition.
Mauser.
Yes. And they have kidnapped, killed, then poured the kerosene and the
grievous offense. Very heinous offense.
Student he has kept Mauser.
Student माने Mauser रखा उचित निजे protection पे.
Custody nothing impose any stringent condition, my lord. So, man, the main witness already examined. My lord, informant.
No, पढ़ी पर आपने देखे ये सब तो कच्ची मुझे पढ़ू चुकी.
आया.
Direct evidence है जो.
भाई जो witness लू, most of witness से nothing. आया. ठीक है, custody रोले ने अपने 1.5 वर्ष ऊपर रोले.
Similar footing like a
Buddha. One of the co-accused religion bill by this honorable court.
Who is that co-accused thing?
ये 23/3 को बोला ना 22/9/2023.
No, you don't stand on the same footing. Sibo
is not my.
You don't stand on the same footing.
He is a similar footing like Gautam Buddha Gowda. PLAPL number 1165/023.
That was rejected.
My lord.
The petitioner is in custody since Since
30/10/2022
30/10/2022 in connection with such case, it is alleged that the petitioner being associated with several other persons and armed with deadly weapons entered into the house of the informant and dragged her husband with the intention of kidnapping him. Subsequently, they killed him. It is submitted that the accusations are directed against one Jogendra
and his son Sillu.
Jogendra and his sons, but not against the petitioner. Stop. Learned Counsel for the Learned State Council, however, submits that several witnesses, including the informant, who is the eyewitness, has clearly stated that all the accused persons were involved in the alleged occurrence. Copies of the depositions of all the 22 witnesses examined so far are available in the case record. It is revealed that the informant, bracket PW1, PW2 and PW3 have stated in vivid details about the occurrence, including the role played by the petitioners, by the accused persons, including the petitioner. Though Jogendra appears to be the principal accused, undoubtedly, yet the petitioner is also involved in the occurrence. And I don't know what kind of defense either cross examination taku pacharichanti. The accused persons, that is Chandan Behera, Prasanta Kumar Pati, Simanchal Sahu, Gautam Buddha Gowda, and Sanatana Rana, bracket witness identifying the accused persons, had dragged the deceased into the vehicle on that day. Tamandang pachare to kiye nele kuho. You call it? This is fundamental error. You are not, you cannot disprove the case. Let the prosecution prove it.
Yes.
You have to find a fault. Having regard to the fact that there is a strong prima facie case against the petitioner, I am not inclined to allow the prayer for bail, which is therefore rejected.
May I submit my with liberty to move before this additional session of Kodola?
Withdraw for you?
No, liberty.
It shall be open to the petitioner to renew his prayer after examination of some more witnesses to renew his prayer for bail before the court below.
Item number 70. I'm on VC Milan.
Yes.
On VC.
Yes.
This is the process. In this case, the present petitioner was the manager of
Depositions of what?
Deposition, yes, petitioner has to produce on the last question. Yes.
Flash deed, the depositions are available.
Online.
Depositions are available, yes.
Yes, my lord. And both of victim and the mother, both have.
Your deposition actually 164 probably. It's a 164.
No, Miller. No, Miller. They are the depositions 190.
Oh, this is a deposition.
Yes, Miller. They have. They do not have any grievance against the present petition.
No, sir. Flag D contains the 164 statement. Yeah. Yes, this is the 164. Anyway, we'll see the 164 also.
No, I think we'll.
More duita mamu ko ghar ko more.
And 164 also he has not implicated the present petition. She implicates two ladies only, madam. There are four accused persons, the Kumari Kuldeep and Sulochana Bari. She doesn't identify the lords also.
No, what is the allegation against this man? Who is this?
He was the
Rama
manager
Patra?
of a lodge. He was manager of a lodge mill. It is alleged that the victim was actually was subjected to rape in that particular lodge. But the victim doesn't say anything about this. She has not identified the lodge. She doesn't name.
Have you seen it? Yes, Mr. Mishra.
And he's in custody since
The victim only says that Sulochana mate ek lodge ko nahi jaye, ek room re chhadi deyi pade asla.
Yes.
No allegation of
Anything.
notice has been served.
No, my lord, notice has not been served. 376(3) is there.
Yes.
But
Wife of the petitioner, my lord. But case of single blow, my lord.
Living peacefully, assault to the daughter, Jayamati Mudali, means who Yes. ଏଠି କଣ କଲେ ସେ ହସ୍ପିଟାଲ ନେଲେ ନା ନେଲେ
ନାଇଁ ହସ୍ପିଟାଲ ଜଙ୍ଗଲକୁ ପଳେଇଲା
କାଠ ସାହାଯ୍ୟ
ବଟ୍ ସିଙ୍ଗଲ ବ୍ଲକ୍
ପକାଇ ଦେଇଥିଲା ଚଳଚମ୍ପି ଗ୍ରାମର ଲୋକମାନେ ମତେ ଫୋନ କଲେ ମୋର ଝିଅ ଦେହ ଖରାପ ଅଛି ଦେଖିବାକୁ ଆସ
ଏକ କାଠ ଫାଳିଆରେ ତାର ସ୍ତ୍ରୀର ବାମ ପଟ କାନ ମୁଣ୍ଡକୁ ଢୋ କରି ଏକ ଶବ୍ଦ ତାଙ୍କ ଘର ଭିତରୁ ହେବାରୁ ମୁଁ ଓ ଅନ୍ୟମାନେ ଘଟଣା କଣ ହେଲା ଭାବି ମୁଁ ତାର ମା ରୁକା ମୁଦଲି ଓ ଗାଁର କେତେକ ଲୋକ ଯାଇ ଘଟଣା ଦେଖିବାରେ ଆସାମୀ ବିଜୟ ମୁଦଲି କୋରାପୁଟର ସେ ଏକ କାଠ ଫାଳିଆରେ ତା ସ୍ତ୍ରୀର ବାମ ପଟ କାନ ମୁଣ୍ଡକୁ ଏକ ପାହାର ମାରିଦେବାରେ ସେ ଘର ଭିତରେ ଗୁରୁତର ଆଘାତ ପାଇ ଘଟଣାସ୍ଥଳରେ ଚେତାଶୂନ୍ୟ ହୋଇ ନିଶ୍ଚଳ ପଡିଥିବାର ଦେଖି ଆସାମୀ ବିଜୟ ମୁଦଲି ଭୟ ପାଇ ସେ ଗାଁର ନିକଟ ଜଙ୍ଗଲକୁ ଧାଇଁ ପଳେଇଲା
କେତେ ଦିନ ରହିଲେଣି କଷ୍ଟଡିରେ
that is 12/4/2023 my lord 12/4/23
Correct. The petitioner is in custody since 12/4/2023 in connection with such and such case. It is alleged that the petitioner dealt a blow by means of a wooden plank on the which struck the head of the head of his wife, ultimately causing her death. Being frightened, he ran away to the nearby jungle. Stop. On receiving information, the parents of the deceased came and took her to the nearby hospital, but she did not survive. It is admitted that the occurrence took place out of a sudden quarrel without any premeditation. Moreover, only one blow was given. Parallel State Council has opposed the prayer for bail by submitting that an independent witness has clearly stated about the assault by the petitioner. After considering the rival submissions and on going through the materials on record, including the statement of one, कौन से लोगों ना?
Durujya
Muduli, who is the neighbor. This court finds force in the submission that the act was without premeditation and most probably arose on the spur of the moment. Stop. Considering the above, and the period of detention in custody, I'm inclined to allow the preferably. Each day appearance.
Item 73.
The Lordship, this is case under section 302 IPC. A affair is unknown and the accused was arrested on 10/4/2023 and the accused person was brought by police before the witnesses Pavitra Naik, who is a witness to the TI period on 10/4/2023, and they admitted and they confessed before the police, which is not admissible in the eye of law. On 11/4/2023, the photographs of the accused were taken by calling one photographer, and the TI period was conducted on 22/4/2023, that is after 12 days of the alleged occurrence. And if your honor look into the 161 statement as well as 164 statement, no overt act has been attributed to this accused. Neither he was armed with any weapon or overt act is been attributed to this accused. Rather, after the occurrence, this accused fell on the ground and became senseless. And he is in custody since 10/4/23.
You were identified in the test identification period.
Last occasion, Lordship called that.
Yes, that is there.
TI period report.
Yes.
Prior to TI period on 10/2/23, the PI before the witness of the TI period, I was brought by the police and shown to the witness who has identified in the TI period. And he has already been examined.
The last occasion he stated that he was not identified in TI period. When the report was called for, then he stated that the police has bring that witnesses and identified that. And the knife was seized from the spot.
Yes, knife was, but he was not armed. There is no evidence or material or record that he was armed with any knife or any overt act has been attributed to this accused person. And apart from that, he has been examined twice by the police. On earlier occasion, when he was examined on 5/4/2023, he has not spoken anything about the occurrence. Subsequently, he was brought by the police on 10/4/23. Before the witness, who is a witness to the TI period, and he has been examined in this case. And he has not deposed about TI period in the court in his evidence.
No, sir. No. The petitioner is in custody in connection with such and such case. The prosecution case is that some unknown persons committed the murder of the victim who was staying in a rented house.
He was coming from the office mail at that.
Two persons were seen by the officials of the company in which the petitioner was working running away from the spot. When they went inside the house, they found the victim having sustained bleeding injury in her neck and was lying unconscious. She was shifted to the hospital where she was declared dead. The petitioner, insofar as the petitioner is concerned, there is some evidence to show that he had earlier threatened the deceased of dire consequences. He has also been identified correctly by the witness
Vibhuti Bhushan Bhanjadev.
Vibhuti Bhushan
Bhanjadev
in the test identification period.
He was brought before him by the police on
Learned counsel
earlier
for the
occasion.
Learned counsel for the petitioner submits that the sanctity of the TI period cannot be that no sanctity can be attached to the report of the TI period, since the petitioner was brought by police before such identification. Stop. There is no material to hold so, as there is clear endorsement by the court below as to the manner in which the TI period was held.
Already, sir, witnesses has been examined, TI period, witnesses has been examined in this case, sir. And he don't speak about the TI period in the court.
TI period witness has been examined.
Yes, sir. And he has not spoken about TI period.
Where is that? Where is that deposition?
I will submit the deposition. I have asked for the copy because only on 6th of this month, 6 tarikh on 6th, the evidence was recorded of that witness, Pavitra Naik, who is a witness.
All right, leave this matter next week. Then counsel for the petitioner shall file copy of the deposition of the witness to TI period.
Yes.
Item 74.
Petitioner custody since 29/8/23, my lord, for the offence under section 458, 395, 25, 27 Arms Act, my lord. In the meantime, charge sheet has submitted and all the stolen article has already been recovered, my lord.
Have rejected the prayer of one Ajmer Ali.
Yes, my lord.
Same.
1 lakh, from him 1 lakh seized. From
Same
the
order.
present petitioner, 46 lakhs has been seized, my lord. 46
Permitted to withdraw, my lord.
50,000.
Withdraw.
Permitted to withdraw.
Item 75.
May I please? On behalf of Mr. Divya.
Yes.
Petitioner is in custody more than a year, that is 5/2/2023, for alleged offence.
Five hundred and six POCSO Act.
At 23, my lord. In the meantime, investigation has been completed, charge sheet has been filed, my lord. The petitioner is a young boy, my lord, and the informant is a married lady, my lord. And allegation is that, my lord, in the absence of husband of the informant was regularly absent, my lord. Since last 2 years, my lord, they developed a love relationship.
Lordship turn to page FIR, my lord. Allegation against one Punya and Gogono. Those were both are assaulted to the husband of the informant, my lord. So far as the petitioner is concerned, my lord, Rusia Naika, Omino Naika, Moini Naika, Mitu Naka, Imane Sojogore, Kori ei କାର୍ଯ୍ୟଟି ହୋଇଛି. That is the allegation.
In association with Amino Nahako, Moino Nahako, and Mitu Nahako. They are the petitioners.
Yes, ma'am.
3 petitioners.
3.
No, but who assaulted him?
Main assault, Gagan Nag and Punya Nag.
Punya Nag.
They
are not
violent.
here.
And this present petitioner were instigating.
The petitioners are in custody since
38/2023.
38/2023 in connection with such and such case. It is alleged that the petitioners instigated the main accused, the principal offenders, namely Punya Nahak and Gogono Nahako, who assaulted the husband of the informant by means of sword, kati, by means of kati, causing fatal blows on his head. Stop. Perusal of the materials available in the case diary reveals that insofar as the petitioners are concerned, there is no allegation of assault against them. It is only alleged that they instigated the co-accused persons, the principal offenders. It is also such allegations also appear to be general and omnibus in nature, taking into consideration the above facts as also the period of detention and custody. I am inclined to allow the proof. Each the appearance.
Item number 80. Next question. 20B2C, custody since 17/6/2023, that contraband ganja was seized from the road, and the informant stated that on reaching at the spot, they found that one person was sitting on a poly bag and another person was was sitting on a motorcycle. Page 10, man. This starts from
middle person. We
Yes.
noticed that four
They
number
are
of
waiting
polybags
in a
have been
lonely place on the roads.
stopped, and one person is sitting on the polybag and another one is sitting on the black red color Hero SDF motorcycle bearing external such and such, which is stand there. After seeing the police vehicle, the said two suspects person tried to flee from the spot by getting this opportunity of dense forest. But our raiding party could able to apprehend by chasing them. After reach at the spot, we found some suspicious article and phone number of polybags from which acute smell of ganja is being emitted. On being asked the suspect person, they disclosed the name as Siba Pradhan and Ranjit Pradhan. They were there, my lord. Ranjit Pradhan was present at the spot.
Ranjit Pradhan is the
Yes, my lord. 120 kg of ganja.
Seizure list, my lord, will be
Shala.
place of seizure is, my lord, in the road.
Shala.
Interval local person.
कितने दिन रोलिंग?
Around 1 year. 7
1 year हो देखिए 1 year हो देखिए नहीं. List one moved.
এটা ମୁଁ not press କରୁଛି move back and move.
All right, all right. Yes. We permitted to withdraw with liberty to renew his prayer later.
Yes.
All right. The remaining matters are ରହିଗଲା. We'll take it up next week.
Only
Malad, one Passover matter was there.
rank for interim bail সেটা 2 রে
Malad, I mean this
আচ্ছা।
one Passover.
আসতে মিস্টার বোস মাথায় ডর লাগুছে আগে। All Passover matters will be taken up next week.
Malad, ଟିକେ ଉପରେ ଖାଲି କରିଦେଲେ ଖାଲି ପଳେଇ ଆସିବ ଟିକେ ଜଲ୍ଦି।
ନାଇଁ ସେମିତି ହବନି। ସେ ଯେମିତି ଆସିବା କଥା ସେମିତି ଆସିବ ସେମିତି କଲେ ହବନି ଆଜ୍ଞା।
ହଉ ଆଜ୍ଞା।
Yes, Mr. Patil, what will you see?
Oh, that is interim application, Lord. Item 2, Passover item.
Interim application for interim bail.
Lordship entertain, otherwise next week, Lord. Interim application, custody since.
On what ground? On what ground are you?
18/7, no, only domestic responsibility, Lord. Repairing of the house.
कौन ऑफेंस कौन?
Offense 302 में.
देखिए आरो वीक आसो देखियो
आगे
आरो वीक
आगे
केतरा पास ओवर थिला 17 थिला आरो वीक रे देखियो from tomorrow there is only one day, it will be second appeal.
Right.